Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 17th, 2026. We have 11 bills on the docket. We're going to start off with Senator Lewis Young with Senate Bill 533. Welcome.
And thank you very much. I am Senator Karen Lewis Young. I represent District 3, but today I am here on behalf of a delegation bill. I will be brief because this is a bill you've heard a few times before. We have been attempting for the last several years to adjust the compensation of the Frederick County Sheriff Department. Well, not the department, the sheriff function. The reason for that is that the current salary is not competitive. It is $125,000. It is not commensurate with the responsibilities. It is far less than several other counties with a population far less than Frederick County. So what is different this year? We're doing a few things different. Right now, there isn't a cross-file in the House. The plan is, assuming you all move this ahead as you have in the past, I am willing to take it across the street. The other thing that we are doing different is we are pegging the salary to 82.5% of the Frederick State's attorney salary. What that will do is every 4 years, there will be an adjustment to be aligned with that salary. That way we don't have to keep going through these hearings. Of course, the salary cannot be adjusted during those 4 years, only once every 4 years. And of course, this year is critical because there's an election, and should you pass this bill again, it would go into effect in January of 2027. With that reminder and description, happy to answer any questions. Thank you for your time and attention.
No, that's good. Questions from the committee? All right, seeing none, thank you very much, Senator.
Thank you.
Thank you. All right. With that, that'll end the hearing for Senate Bill 533. We'll now move on to Senator Watson with Senate Bill 620. Okay. I hear Senator Watson's on his way. All right, we're going to skip down to Senator McKay. Let's do Senate Bill 482. That works for you? Excellent. Okay.
Mr. Chairman, Mr. Vice Chair, members of the JPR Committee, Senator Mike McKay to present Senate Bill 482, Criminal Law Interference with Critical Infrastructure or a Public Safety Answering Point. The primary intent of this bill is to strengthen Maryland's criminal laws regarding the interference with critical infrastructure and public safety answering points. That's our 911 centers. It updates Section 7-30302 of the Criminal Law Article to provide specific protections and penalties for essential services. This bill introduces a broad but robust definition for critical infrastructure to ensure that vital state assets are protected. These are systems and assets, both physical and virtual, and they're vital to their destruction or capacity would have a significant impact on the state or its local jurisdictions. Now, the definition specifically covers related to public and economic security, public health and safety, public transportation utilities. The legislation closes the gaps in the current law by prohibiting specific harmful actions against these systems. It prohibits any person from committing an unauthorized computer-related act with a specific intent to interpret or impair the functioning or critical infrastructure of a public safety answering point. Crucially, it gives and creates the new prohibition against acts that deny access to authorized users or successfully interprets the operation of these systems regardless of the specific intent to do so. It establishes, Senate Bill 482 establishes a significant felony penalty for those who reflect the gravity of interfering with essential public services. Violations involving the intent or interruption of these systems are classified as a felony, punishable up to 5 years in prison or a fine of $25,000. Violations as a result for the actual denial of access or impairment of these systems carry a more severe penalty, up to 10 years in prison or a $50,000 fine. Finally, the bill ensures that these protections sit alongside existing laws and safeguards for safe government operations, electrical and natural gas infrastructure, healthcare facilities, and public schools. You see, Senate Bill 482 recognizes that there's an increased digital and interconnected world that has the capacity or destruction of our infrastructure doesn't cause just an inconvenience, but it actually threatens the very security and health of our citizens. By creating a clear felony for these consequences and these acts, they provide law enforcement prosecutors with the tools necessary to protect Maryland's most vital system. Of course, this bill will take effect October 1st, and look forward to a favorable report.
Thank you very much, Senator. Questions from the committee? Senator West has a question.
Actually, just a clarification, if I could. Thank you, Mr. Chair. In my packet, I have a reprint of a Senate bill with an amendment on it, and the original bill did not include the words intentionally, willfully, and without authorization commit these acts. Those words have been added. I assume you have adopted the amendment as yours.
That is correct. I have that, and that's what we've sent out to everybody. I failed to mention that we did have that amendment.
Great. Thank you.
So, yes, sir. Thank you.
Sure.
Thank you. Thank you, Senator McKay, for bringing this important bill. I just, very briefly, I'm trying to remember the kind of scenarios we are going after. I think there's a couple of high-profile cases, let's say, in the last several years where people went into substations or different infrastructure like that and disabled it and caused quite a lot of havoc. Is that sort of where?
That's where we're coming at, yes, ma'am.
Okay.
And just protecting those crucial points. I don't have the specifics, but you are correct.
Okay.
At the end of the day, we in the General Assembly need to have a policy or pass a procedure that shows that we're sincere in the destruction of our 911 centers.
Okay, thank you.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you very much, Senator. Thank you for being flexible. All right, I see that Senator Heddleman is here. Wait, oh wait, sorry, my apologies, my apologies. You have two people here signed up. Is Sarah Sample is here? Is Sarah Sample here? Come on, answer. And then we have another guest joining us virtually. Sarah Anderson, go ahead.
Thank you, Chair, members of the committee, for having me. My name is Sarah Sample, here from the Maryland Association of Counties. We support Senate Bill 482. We've supported this for a couple years. We think this is clear, it's practical, it appreciates the severity of the offense. We've seen these attacks are escalating across a number of different divisions, so that's certainly why we think this is very important. We don't usually weigh in on criminal penalties, but this is something that is specific to the systems that we use to try to protect residents and serve residents. And we think that the changes in the penalties they really appreciate the impact level. This can impact thousands of residents in a very serious way. So we appreciate that, and we would support Senate Bill 482. Thank you.
Thank you very much. All right, is Ms. Anderson here? She's in the Zoom room.
Hi,
Welcome.
I'm here, but I'm here for the Clean Slate Act.
Okay. We have you signed up here for Senate Bill 482, but we'll hold on until we come back to the Clean Slate Act.
Okay, thank you so much.
Awesome, thank you. All right. With that, that concludes the hearing for Senate Bill 482. Senator Hedelman is here. Yep, welcome. Now I'm going to go on to Senate Bill 531.
Thank you very much. If we can have the panel come up with me. Thank you very much, Mr. Chairman, members of JPR. I'm Shelley Hedelman from District 11, and I'm very happy to be here today to present Senate Bill 531. I'm actually not that happy, to be honest about it, because I feel like this should not be a bill. We passed a bill in 2020 that was supposed to address this issue. Here's the issue. Somebody, and I want you to kind of go with me a little bit here on the scenario. Somebody has recently been sexually assaulted. They are brought into a police department or law enforcement, and they are, as you can imagine, it's a very traumatic time. And we have learned that there were some law enforcement agencies that were putting a piece of paper in front of a survivor, and in all the tumult, if a survivor was not at the place where they wanted to pursue cooperation with the police department was putting a written piece of paper in front of them called a waiver of an investigation, and asking the person to sign the waiver at that particular moment. As you can imagine, it is a time of trauma, it is a time of tumult, just so much going on, and law enforcement was asking people to agree to not hold them culpable for not pursuing an investigation without their cooperation. We believed, and with the support of this committee, and indeed the entire General Assembly, passed a law in 2020 that outlawed the use of these written waivers. We have recently learned, and you will hear more from the Office of the Attorney General, I serve on the Sexual Assault Evidence Kit Funding and Policy Committee that was created in 2017 that brings together stakeholders across the community on these issues, and meets regularly to discuss what we need to do in our healthcare system, law enforcement, et cetera, to help survivors to get rape kits tested, to hold perpetrators accountable. And in this group, we learned that there are still law enforcement agencies that are asking for verbal waivers from survivors. And it is my belief that that puts a survivor in the same sort of position as a written waiver. So what this bill does is closes that loophole that, frankly, we didn't think existed when we passed the bill in 2020. It is, this is not a time for all or nothing decisions. People are allowed to change their mind. They're allowed to come forward later and say, of course, I'm at a point now where I want to participate and cooperate with an investigation, but it shouldn't be at a time at the beginning, and there should never be a time where somebody is asked to waive their rights. So my illustrious panel here is going to put some more meat on the bones, some real life experiences, but I urge you to report out Senate Bill 531 to close this loophole and to support survivors of sexual assault in their most vulnerable time. Thank you. Just that, a little shorter.
Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the Judicial Proceedings Committee. My name is Carissa Hatfield, and I am with the Maryland Office of the Attorney General, acting as counsel to the Sexual Assault Evidence Kit Policy and Funding Committee, or SAKE Committee, if you need to save a few minutes on naming the committee. I'm here today in strong support of Senate Bill 531. SB 531, as the Senator mentioned, seeks to amend Maryland Criminal Procedure 11929, which prohibits law enforcement from asking victims of sexual assault to sign a written waiver of investigation and/or prosecution in their case. It seeks to expand that prohibition that we set up in 2020 to verbal waivers. Under the proposed bill, law enforcement would not be able to approach a victim of sexual assault and ask whether they'd like to continue the investigation, testing, or prosecution of their case. Under best practices issued by the International Chiefs of Police, law enforcement, quote, should discontinue the use of waivers or forms to not investigate, regardless of the type of crime. Instead, law enforcement should allow victims to approach them when they wish to end the investigation or prosecution of their case, giving victims autonomy and choice. Once this occurs, law enforcement should follow protocols that have been issued by the Maryland Police Training and Standards Commission to further contact the victim after the victim has made the first steps by their own choice. This is because waivers, whether written or verbal, can intimidate, coerce, or pressure a victim not to proceed with their case, even if they would have originally chosen to do so. The statute will not change how law enforcement officers interact with a victim when the victim requests that their investigation end. It will simply provide clarity to law enforcement who need it on this issue and ensure that every victim receives the same level of support, investigation, and service from law enforcement, regardless of where their assault occurred. It is for these reasons the State Committee urges a favorable report on SB 531.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Laura Jessic, the Sexual Assault Kit Initiative and Sexual Assault Response Team Program Manager with the Maryland Coalition Against Sexual Assault, and I think I have the State Committee beat for a title. MCASA is the coalition of rape crisis centers across the state of Maryland, and we are here in support of Senate Bill 531. Sexual assault is a violent and traumatic crime, and when survivors choose to report the assault to the police, they do so in hopes of achieving justice and preventing future harm perpetrators may cause to others. They place their trust in the police to conduct a thorough investigation by collecting and testing evidence, including sexual assault evidence kits or rape kits, interviewing witnesses and suspects, and more. They do all this knowing that they will be asked to relive the worst experience of their life, set aside their privacy, and to make themselves vulnerable to those in positions of authority. Too often that trust is misplaced. In 2020, the General Assembly banned written waivers of investigation forms some law enforcement officers presented to survivors, asking them to abandon the investigation in any hope of justice. These waivers were frequently presented when survivors were vulnerable, intimidated, or met with disbelief. Despite this ban, some Maryland law enforcement agencies continue to evade thorough investigations by verbally encouraging survivors to disengage or withdraw their consent for rape kit testing. This practice undermines the critical role of rape kit testing, perpetuates disbelief of survivors, and reflects some officers' disregard for law enforcement's duty to protect communities and hold offenders accountable. MCASA urges a favorable report on SB 531 to ensure thorough investigations, promote trauma-informed practices, support survivors, and shift investigative culture toward accountability and justice. And I will just add that as my program at MCASA, we contact survivors and notify them all the time for those that signed written waivers, and I'm happy to answer any questions about their experiences with that.
Good afternoon, Mr. Chair and all the esteemed members of the Judicial Proceedings Committee. My name is Katie O'Malley, and I'm the Executive Director of the Women's Law Center, where we support survivors of intimate partner violence and sexual assault, not just women, but also men. And as the Senator explained to you, this fine legislation was presented in 2020, which allowed and then was passed the written waivers to be excluded so that victims in a time of trauma, when they're first reporting one of these horrific events, don't have to make such an important decision. So this is basically closing the loophole, as Senator Hendelman said. And I've spoken to law enforcement, I've spoken to prosecutors. It's basically common sense that the time when a victim is most vulnerable is right after they've experienced a sexual assault, and requiring them to sign a waiver or a verbal acknowledgement oftentimes makes the victim feel, if they change their mind, that they cannot go back and that they cannot pursue those charges. It also has the effects, as you heard from the AG's office, on whether or not their rape kit tests are going to be tested or not. And you'll know from sometimes when rape kit tests are tested, not only is the victim, the present victim, a person who would want to know about this, but there could be other prior victims who have the DNA has been collected that can be notified regarding sexual assaults that have occurred. So for those reasons, we really urge you to report favorably on this bill. And you're going to hear from law enforcement from Montgomery County. So I don't want to steal his thunder, but he'll tell you how this effectually works and how best practices can be so that you don't put victims in this situation. Thank you so much.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Detective Sergeant Jason Baum, and I'm the supervisor of the Montgomery County Police Department's Sex Assault Unit, and I've been a law enforcement officer for 32 years. I testify here today in full faith and confidence that the passage of Senate Bill 531 will in no way negatively affect or impede a law enforcement investigation. I contend that the purpose behind asking for a verbal waiver of investigation is to relieve agencies of their duty to investigate rather than to empower the survivor. The practice of requesting a verbal waiver is nothing more than a continuance of actions currently prohibited by Criminal Procedure 11-929. Courts have long held that the government may not obtain waivers through implicit pressure, imbalance of power, or psychological coercion. When law enforcement, an authority with control over access to justice, requests a waiver from a traumatized victim, it's pressure exercised by authority. Sexual assault victims are often approached by law enforcement at moments of extreme trauma. In that situation, a request to waive an investigation cannot reliably meet constitutional standards of voluntariness. The Constitution limits the government's ability to interfere with access to justice. Asking a victim to waive an investigation is an affirmative act that blocks evidence collection, weakens prosecutions, and prevents judicial remedies. The state cannot bypass its constitutional responsibility by shifting the burden onto victims at their most vulnerable moment. Asking a survivor to waive their right to an investigation risks re-traumatization, violates constitutional and ethical standards, exposes agencies to liability, and erodes public trust. The passage of Senate Bill 531 would restore fairness and accountability, protect survivors, strengthen investigations, and serve the safety of our communities. And I'm therefore respectfully requesting a favorable report. Thank you.
Thank you, Mr. Chairman. This question might be best for Judge O'Malley, but actually she is a lawyer, but just so I can understand the issue, I did not, is this unique to domestic issues, rape and sexual assault, this putting a document in front of victims, asking them to waive investigations and prosecutions? Is this something that is unique to this area of crime?
No.
Okay. And I also find it hard that they would ever be enforceable, given a little bit about what the detective sergeant said, which is a crime is committed, and I've been told that prosecutors have an independent obligation because sometimes victims don't want to continue a case, but the case is important, the prosecutors continue without the victim's consent. Is that correct? In general?
Yes, in general, a prosecutor can choose to continue a case even without a victim's consent.
So have we banned, when we banned this practice in 2020, I was not here, 2020, did we ban it across the board and so it included this particular crime, but all crimes, or did we just micro-focus on this kind of crime?
Maryland 11929 specifically addresses survivors of sexual assault, which is the category that we're addressing here. It doesn't address other crimes. It's just focused on that.
Is there a
population.
reason why you don't have to justify it. Do you recall a reason why it was focused in that way or not?
I also was not here in 2020.
Okay, fair enough.
But I can tell you the reason that we focused on sexual assault survivors was this was a situation that was uniquely presented to the Sexual Assault Evidence Kit Policy and Funding Committee.
Okay.
And it was an issue where we were seeing that victims were not getting their kits tested, and they had no idea why. And it was finding out later that they had signed one of these waivers and not understanding what was happening.
Yeah.
And so that's why we forwarded it through, I believe Senator Heidelman was a delegate at that time, when this was, or were you a senator?
I was making the transition, actually.
You were making the transition.
I was both.
You were both at that year. So it was moved forward as Senator Heidelman has long been a proprietor and an advancer of our causes for this.
And I can do some research myself, but I do find it really difficult to accept that these would even be enforceable. But that's, you know,
So I
just
think, yeah, and
victims of
I
crime.
hear you.
I'm sympathetic.
Yeah.
And there may be some rare instances where that could make some sense. I get that, but across the board, this does not seem like a good practice at all.
Absolutely.
In any circumstance, including this one.
Absolutely.
All right.
Yeah,
And
I
then
would say the reason that we are concerned about this and forwarding the bill today is
I'm not
because
trying to
we have.
expand your bill, I
yeah.
just wanted to know.
Yeah.
And then lastly, did everybody, and this may have been satisfied, the Maryland Crime Victims Resource Center, is anybody, I see that they support it with some amendment language to strengthen it so that law enforcement may not encourage a victim not to prosecute or decline prosecution of the alleged offender. Is that something you all have seen or, okay, so if we ask about that, you can follow up with us later. All right, thank you.
Thank you.
I'm just going to ask the most obvious question then. Why would a law enforcement agency ask someone to waive their right?
Yeah.
Just the fundamental question.
That's what I'd like to know.
I mean, I think what we have seen both historically with the written waivers and currently with these verbal waivers is that, you know, through no fault of their own, law enforcement has a high volume of cases. They often are trying to move things through the process, and where they may not believe a victim or believe there's not enough evidence to move the case forward or any other circumstance, they may try to push forward either a verbal or a written waiver to get the case off of their decks, as it were.
I'm going to elaborate. Sorry?
Yeah, I don't think they're enforceable, but I'm having trouble.
Okay, Mr. Chair, to follow on that,
Actually, this is really important. Laura has real world experience.
Historically, the written waivers, many agencies had the bottom of it, like the top says that you're waiving your right to an investigation. The bottom says that you agree not to come forward again or hold the agency liable for not pursuing an investigation. Not all of them. I've seen ones that don't have that, but I have also seen ones that do have that. And in practice, I've had cases where survivors were too intoxicated to consent to the medical forensic exam, but at the same time, law enforcement had them sign the written waiver. So this has been in practice for a while. And again, the written waiver ban has worked, but we do have those agencies that are verbally working their way around it.
Going back to 2020, I had law enforcement come in and sit in my office and say they opposed the bill and they wanted to be able to continue. I mean, it was a cover their behinds kind of action. I think there were articles about it in the newspaper and in the press, and so there are times where law enforcement gets a lot of negative press for not pursuing these kinds of cases, and I think it was a cover their behind kind of action.
thank you, Mr. Chair. To follow on that, I guess the questions are appropriate to either Mr. Baum or Ms. Hatfield. Are there any other criminal situations, crimes, in which law enforcement asks victims to waive any rights they might have at the beginning of an investigation? I've never heard of this happening. Does this happen with any frequency?
So I can speak for Montgomery County and what we've done in the past. What other jurisdictions are doing or have done in the past, I don't know. This form was widely used for every crime when I first came onto the department. We've since, without any legislation, done away with it. We've evolved and realized that this was not a good practice. This was not something we should be doing. This is not something that we should present to victims of crime. So we've done away with that on our own before this even was presented for the first ban of the written waiver. So before that even occurred, we've done away with the written waiver. We've never done the verbal waiver ever since I've been in the department.
Thank you. It just sounds so inappropriate. There's other people in the room here who are not testifying on this bill, but who are involved in law enforcement. If any of them knows of a situation in which this happens and where you feel it's appropriate that it happen, I'd love you to come see me independently and explain to me why you think this would be an appropriate approach. I just can't imagine doing such a thing. Thank you.
Yeah, thank you very much, Senator. Further questions from the committee? All right, thank you all very much. Thank you. All right, looks like with that will conclude the hearing and the testimony for Senate Bill 531. Senator Watson is here, so we're going to go on to Senate Bill 620.
Good afternoon, Mr. Chair, Vice Chair Wall-Striker, members of the committee. For the record, I'm Senator Ron Watson, representing the 23rd Legislative District, and I'm here to ask your favorable report on Senate Bill 620. I'm proud to be joined today by Prince George's County State's Attorney, Ms. Tara Jackson, who is strongly supportive of this legislation, as are all members of the state's attorneys. This legislation makes a targeted and necessary clarification to Maryland's handgun sentencing statute under 4-203 of the criminal law article. Specifically, the bill ensures that prior convictions from other jurisdictions, whether from another state, federal court, military court, or Native American tribal court, are treated the same as Maryland convictions for the purpose of enhanced sentencing when a defendant reoffends. Under current law, enhanced penalties apply when a defendant has prior Maryland convictions under 4-203. However, there's a gap in the law. If an individual has committed the same conduct elsewhere, conduct that would constitute a violation of Maryland law, but was convicted outside this state, that conviction does not clearly qualify as a prior offense for enhancement. Senate Bill 620 closes that gap. This bill provides that prior convictions from another jurisdiction counts if the offense, had it been committed in Maryland, would constitute a violation of the same handgun statutes listed in 4-203. This ensures fairness, uniformity, and consistency in sentencing. This legislation does not create new crimes. It does not expand the underlying prohibition on wearing, carrying, or transporting a handgun. It does not alter the existing penalty structure. Instead, it ensures that repeat offenders are treated as repeat offenders regardless of where the prior conviction occurred. Maryland's enhanced penalty framework reflects a legislative judgment that individuals who repeatedly violate handgun laws pose an elevated public safety risk. When a person with a prior handgun-related conviction reoffends in Maryland, the fact that their earlier conduct occurred across state lines should not immunize them from the enhanced sentencing provisions. This bill simply makes clear that prior conviction, wherever it occurs, counts. The bill also maintains existing procedural safeguards. Where mandatory minimums apply, the state's attorney must provide written notice at least 30 days before trial of the intent to seek the enhanced sentences. So in short, Senate Bill 620 promotes sentencing consistency, interjurisdictional parity, and public safety accountability. This is a common sense clarification that aligns Maryland law with many other states in how they treat offenses for repeat firearm violations. And for those reasons, I respectfully ask for a favorable report on Senate Bill 620, and I'd like to turn it over to our Prince George's County State's Attorney, V. Tara Jackson.
Thank you, Senator Watson. Mr. Chair, Mr. Vice Chair, thank you for having me today. And thank you for all of the continued work and partnership in creating safer communities throughout the state of Maryland. And Senator Charles, good afternoon. Last year in Prince George's County, we had a significant decrease really across the state in overall violent crime compared to 2024. Carjackings were down over 50%, homicides were down 40%. And though crime was down across the nation, it wasn't down that drastically. And so we are grateful, we are thankful. And that progress reflects the hard work and collaboration of all of our law enforcement partners and strong collaboration with county leadership, state leadership, community organizations, and residents who remain engaged. But we have a lot of work to do. Still, too many persons in our communities across Maryland are carrying handguns. Too many persons are victims of gun violence. In fact, just this year in Prince George's, we have already had, unfortunately, 12 homicides, all of which were committed by people using guns. And then there's shootings, carjackings, armed robberies, and assaults. In 2024, 1,529 arrest warrants we had in Prince George's 1,529 arrest warrants involving a 4203 handgun charge. And in 2025, we had 1,360 arrest warrants involving a 4203 handgun charge, which is wear, carry, and transport. There are far too many illegal guns on our streets. Oftentimes, I say this as I move around the community, oftentimes people don't leave their homes intending to use the gun that they are carrying, but they find themselves involved in an altercation or an argument that escalates, and out comes the gun. And we all know that no good choice or no good comes from that choice. In fact, it's not unusual for us to find that our defendant and victim are both carrying guns, and oftentimes, sometimes even witnesses. So what do? We want to make sure that we send a strong message to those who choose to illegally wear and carry handguns and do so repeatedly without regard for the law. Maryland Criminal Law 4203, as Senator Watson said, prohibits persons from carrying handguns and provides for enhanced penalties where defendants have been previously convicted of that same offense, wearing and carrying a handgun. This legislation is being proposed because though 4203 provides for enhanced penalties, prosecutors are unable to seek enhanced penalties when their firearm conviction occurred outside of Maryland. Under current law, we are required to treat those individuals as first-time offenders, even when they have already been convicted of unlawfully wearing and carrying in another jurisdiction. For example, in one of our recent cases in our county, the defendant was arrested for unlawful possession of a handgun. That individual had several firearm possession convictions in another jurisdiction. And despite those prior convictions under the current law, we were required to treat the individual as a first-time offender. As a result, the maximum penalty available to us was 5 years, as opposed to a potential of 10 years as a subsequent offender. Defendants with prior convictions from other states should be subject to Maryland's subsequent offender penalties, but right now they are not, and that is a dangerous loophole. In fact, in other of our state laws, we see that the legislature has provided for just what we're asking for here today. I think in the context of DWIs, if you have a prior DWI conviction in another jurisdiction, that counts as a subsequent offense as it relates for the purposes of enhanced penalties. We must recognize that in our region, movement across state lines is fluent and it's constant, and crime does not stop at the border. It is not unusual in Prince George's County for a criminal defendant to have a record in Virginia, Maryland, and the District of Columbia. And this issue, I know, affects not only Prince George's County, but many of our other counties that border another state or the district. We do regularly encounter individuals who do not reside in Maryland, but are arrested here for firearm possession offenses. In fact, of the 1,529 arrest warrants that I mentioned earlier involving a 4203 handgun charge, 500 of those individuals had addresses outside of Maryland, and that was for those 2024 cases. And for the 2025 cases of the 1,360 arrest warrants involving the same charges, more than 400 resided outside of Maryland. That is why I've worked with the sponsors of this bill to bring it forward. Thank you again to Senator Watson, to Senator West for sponsoring this important piece of legislation. I want to be clear that this legislation is not an attempt to penalize people for lawfully carrying firearms or for exercising their constitutional rights. It simply ensures that there are no loopholes in our gun laws. Individuals who choose to repeatedly violate firearm possession laws in any jurisdiction are a danger to our community and should not receive a pass simply because they crossed a state line. In a region where movement is constant, accountability should not stop at the border. I look forward to your favorable consideration of this bill, and I can answer myself or Mr. Widman, who is the chief of our gun unit, are available to answer any questions that you may have.
All right. Thank you, Madam State's Attorney and Senator. Thank you. Questions from the committee? All right. Cold bench. There you go. Thank you very much.
Thank you.
All right. With that, that'll conclude the hearing for Senate Bill 620. All right, I see Senator Quarterman is here. We're going to go with Senate Bill 640.
Thank you, sir. Okay, put my pen off. Thank you, Mr. Chairman, Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity today to present Senate Bill 640, Post-Conviction Release, Crimes Resulting in the Death of a Young Victim. Members, before us today is a story of tragedy. Tragedy that has struck our community on multiple different levels. At approximately 7:40 a.m. the morning of April the 14th, 2021, Hagerstown Police responded to the residence of Ashley Nicole Franklin for a call about an infant who wasn't breathing. That infant was Ashley's daughter, 10-month-old Bella Franklin. Approximately an hour later, at 8:36 a.m., Bella was pronounced deceased at Emeritus Medical Center. Bella died of malnutrition, which meant that as Bella's primary caregiver, her mother, Ashley, didn't provide Bella with the proper nutrition that she needed. When Bella was born, she weighed 8 pounds, 2 ounces. 10 months later, when Bella died, she weighed 9 pounds, 8 ounces. Members, many of us in this room have children of our own, and we all know a child's birth weight should double by about 6 months, nearly triple by a year. Bella gained 1 pound, 6 ounces in 10 months. When the funeral was held for Bella, her own mother failed to appear, didn't have the decency to show up for her own child's funeral. Fast forward approximately 6 months to October 2021, Ashley Franklin was indicted. However, over the course of the next approximately 2.5 years, due to a variety of reschedules, continuance, et cetera, the trial was pushed back to March the 11th, 2024. Ashley Franklin failed to appear in court the morning of her trial date. At the time, there was a courtroom packed with potential jurors waiting to go through the jury selection process. But again, Ms. Franklin was not there. Subsequently, a bench warrant was issued. Months later, Ashley was found in Georgia, where she fought extradition back to Maryland. A new trial was scheduled and began August the 4th, 2025, just a few months ago. According to testimony of the chief medical examiner, for a child's malnutrition to result in death is a process that takes weeks to months. And remember, Bella was only 10 months old, and had gained only 1 pound, 6 ounces in the 10 months of her life. Members, you're going to hear today from Detective Anthony Flegel, who investigates crimes against children for the Hagerstown Police Department. Detective Flegel has been involved in the investigation since the beginning and testified that Bella's ribs were protruding from her body, and she appeared starved and extremely malnourished. She didn't even look close to a child of her age. As Deputy State's Attorney for Washington County, Sarah Mullet-Gomer gave her rebuttal closing arguments the afternoon of August the 6th, she said, quote, "Children are a gift, and this child was treated like trash." After a 3-day trial, the jury found Ashley Nicole Franklin guilty of first-degree child abuse, resulting in the death of Bella Franklin. Ashley Franklin was also found guilty of first-degree child abuse causing severe physical injury, involuntary manslaughter, and neglect of a minor. Members, of what you heard today was not horrific enough. What happens next is what brings us here today. The jury returned that guilty verdict the evening of August the 6th, and subsequently Ashley Franklin was granted a bond hearing, giving her the option to be released from the Washington County Detention Center on a $5,000 bond that could be paid with as little as $500. Think about that. A 10-month-old baby was starved to death by her own mother, who in turn was convicted of first-degree child abuse that resulted in the death, and a variety of other convictions, and she can be released for $500. Washington County State's Attorney Gina Cerencione, one of the 2 prosecutors of the trial, objected to the bond review. Keep in mind, Ms. Franklin didn't appear back in March of 2024 when the trial was originally scheduled, and she filed extradition to come back for this trial. Bond was posted for Ashley Franklin late Thursday night, August the 7th, 2025. An August the 13th, 2025 sentencing hearing was scheduled. Ashley Franklin did not appear in Washington County Court that day, and no one has seen her since. Senate Bill 640 prohibits a court from releasing the defendant after conviction, pending sentencing or appeal if the defendant was convicted of a crime of violence or child neglect that resulted in the death of a child under the age of 14. In the most serious and tragic cases where a young child has lost their life, this measure ensures that a convicted individual remains in custody during the post-conviction process. It is absolutely unheard of that anyone would be released back into the community after a conviction for these heinous acts. We're not talking about bond review prior to adjudication. We're not talking about the fundamental legal principle of presumption of innocence. We're talking about a conviction, a guilty conviction where a child's life has been lost as a result of a crime of violence or child neglect. You'll see it was uploaded a letter of support from our local state's attorney, as well as support from the Maryland State's Attorneys Association. Additionally, you're going to see and hear testimony today from Justice Sake, a leading advocate for victims of child abuse in our community. Those of you who've been around here for a while may remember the story of Baby Justice and Justice Sake's efforts that led to the passage of justice law in 2016. You also see and hear testimony today from the Maryland Crime Victims Resource Center. I would be remiss not to acknowledge opposition from the judiciary. However, this legislation strengthens public safety. It reinforces the seriousness of crimes involving the death of a child by setting a clear standard for post-conviction release in these limited and severe circumstances. This legislation provides certainty for the victims and the victims' families. This legislation honors the legacy of Bella. We thank you for your consideration, and we respectfully request a favorable report on Senate Bill 640. Don't hear.
Good afternoon to members of the committee. My name is Detective Anthony Flegel. I work at Hagerstown City Police Department. I've been there for approximately 25 years. Unfortunately, I was the one that had to handle the investigation involving Bella. The medical examiner ruled it a homicide and said it was due to malnutrition and neglect. But in all honesty, basically, Bella was starved to death. Her life was terrible. She had no chance, and her mother didn't give her anything she needed to live life fully, and so forth. Ms. Franklin, from the time that Bella passed away, immediately fled the area with her 2 other healthy children so that the Department of Social Services couldn't put eyes on them to make sure they were healthy. As Senator Quarterman indicated, Ms. Franklin didn't even show up for her own daughter's funeral, and we had to track her down, obviously, to get her into court. She was eventually indicted. As Senator Quarterman indicated, And then her first trial, like was stated, she didn't show up. We found her 6 months later in Georgia. She fully fought extradition to come back to Maryland to fight these charges. And like I said, the most concerning thing was she was convicted and she received a 90-year jail sentence. And she was subsequently given the opportunity to post bond, which seems to be an issue with the court system in some manner. And to this day, we still look for her. We can't find her, and at this point, we don't know where she is. And this wouldn't have been an issue if she wouldn't have had that ability to post a bond when it initially occurred. I thank you all for your time, and I hope you support this measure.
Good afternoon. My name is Richard Myers, and I'm here on behalf of Justice's Sake. Today, we strongly support this bill addressing the post-conviction release of individuals whose crimes resulted in the death of young children. This bill recognizes the fundamental truth: when the victim is a child, the harm is irreversible, and our laws must reflect the weight of the loss. By limiting the post-conviction release opportunities in these specific and devastating cases, the legislation helps protect families from ongoing trauma, preserves the integrity of the original sentence. Importantly, this bill does not take away from anyone's constitutional rights. Defendants already received full and due process, final appeal, full access to required post-conviction process. What this bill does ensure, finally, in these cases, is a young life was ended, and consequently, the crime cannot be undone. Passing this bill would affirm that Maryland's justice system values the safety of our children, supports victims' families, and stands by the sentence imposed for the most serious, irreversible crimes. I respectfully urge the committee to support this legislation, Bill 640, and help ensure that no family who have lost a child to a violent crime must continue to relive their trauma through repeated release hearings. Thank you.
All right. Good afternoon. My name is Laura Wilt. I'm the senior attorney in Baltimore City for Maryland Crime Victims Resource Center, and I'm here asking for a favorable report on Senate Bill 640 today. We believe the bill is very narrowly tailored to address one of the most serious crimes against our most vulnerable population. Pretrial release is a totally different thing, as Senator Quarterman pointed out. Pretrial release, we have statutes, and it tells the judges exactly what to consider before the trial. Are they a flight risk? What's the probable cause against this defendant? Are there concerns for the danger to the community? All those things are considered, but this is different. This bill addresses after a finding of guilt, after the accused is no longer presumed innocent, the family of the child, the judge, everyone has listened to all the facts and have found that this individual is responsible for the death of a child. The defendant should be incarcerated prior to sentencing. It is incredulous to most of us that we would need to have legislation to do this. The only objection we've heard is that it's a limit on judicial discretion. Our judges are entrusted with some of the most serious decisions. We know that they will still have complete discretion at sentencing. So if there ever was a situation again where a judge is facing facts in this that are covered by this statute, and they think to themselves, this defendant does not deserve incarceration, they still have the ability to hold sentencing that same day and sentence. It does not change their discretion when it comes to sentencing. It just says if you're going to schedule sentencing on a separate date, you must incarcerate. So sometimes guardrails are important and need to be put in place for discretion, and we ask that a favorable report be passed on this bill to do that. Thank you.
Thank you very much. No, first, you're an assistant state's attorney?
Yes, sir.
Do we do this anywhere else in the criminal law? This whole idea of taking away or essentially forcing the court to make a decision the day after, I guess, the guilt has been found?
Oh, I think many, many times, well, whenever you get a guilty verdict in, the judge has to, at that time, determine, are we going to sentencing today, or are we going to go sentencing later?
Let me back up, because what this is saying is if they don't decide to, I guess, to have to hold a sentence, they have to incarcerate. What I'm asking is, once a finding of guilt has been made, is there anywhere else in the law where we tell the court that if you don't render a sentence, that you have to incarcerate immediately? Essentially, I'm asking, is this breaking new ground?
I believe it's a parameter on a judge's rule. I mean, there's things like minimum sentences.
That's not what I'm asking, though.
Right.
What I'm asking is, do we tell a judge that you have to incarcerate if you don't decide to render a sentence today, since a guilty finding has been rendered?
I can't think of another instance, but that's why this is so narrow. I mean, look how narrow this is. This is causing the death of a child by a crime of violence.
Anyone is...
And I would argue that our children are different, and they're treated different in every other part of our, when you're drafting every legislative bill, and you're talking about children, they deserve special protection.
All I'm asking is if we're taking like if we're going down a new road. That's what I'm trying to do.
It may be. If I find out that we're not, I'll love to send you that. But I think it takes an extreme situation to realize that we had this need.
Any idea why the judge did what the judge? Well, you wouldn't know because it didn't have
it's not my jurisdiction.
It didn't have any jurisdiction. Okay, thank you. I don't know. Do you have any idea, Senator?
So, well, I think the only thing I would add, I wouldn't presume to speak for the judge, okay? But I would go back to your previous statement, Senator, of, look, this situation occurred, and I understand your question as far as do we do this anywhere else? If it's the will of the committee to broaden it, I'm certainly happy to that amendment, because I would agree with you that when you're talking about murder and death of any individual, that is something I would definitely be interested in. But we narrowed it specifically because this is what happened in our community, and this is what happened to this child, and that is why we brought this forward, because this has happened, and we don't ever want to see this happen again, and it should not happen again. Now, if things of this have happened in other situations, again, I am more than open to broadening that.
When did this happen?
About 4 or 5 months ago, late August of 2025.
And the person absconded.
I'm sorry?
And the person absconded, and now we can't find them.
Gone. Last time that she was seen was the day that she was given that, what in essence was a $500 bond for starving her child, and no one has seen her since.
Is there any, and again, I'm asking because I'm not familiar with the case. Did the mother have some sort of drug abuse issue? Or, I mean, because this doesn't sound like something that someone without something going on would do.
Well, I mean, she had a pattern of not showing up. I know that. I can't speak to what her habitual uses were one way or another.
Thank you.
Yes, sir.
All right, further questions from the committee? All right, Senator, thank you very much. Thank you to the panelists. With that, that'll conclude the hearing for Senate Bill 640. We'll now move on to Senate Bill 514. All right, good afternoon, everyone. Senator Smith here to enter into the record Senate Bill 514, which is a bill that you all have seen before, which is a bill that will create a third-degree assault statute. Before we get into this, I want to thank the library. They did a little bit of research for me, and they found out that 1995 was the first time that Maryland lawmakers attempted to create an assault statute into the code. It was a common law construction before then. And when they did so, they created actually 4 degrees of assault. And that lasted for a year. Then there was a work group in the interim. And they came back, with with first and second degree assault, which is the regime that we've been living under since that interim work was done by the General Assembly. And so the bill before you is actually modeled after, it's not identical to, but modeled after House Bill 488, which was back in 2018, when then Delegate Dumais and Chairman Valerio, so Vice Chair Dumais and Chair Valerio, introduced this bill. It was a bipartisan product that had bipartisan support. Dorothy Lenig, who then at the time was working with House of Ruth, supported the bill. Steve Kroll from the Maryland State's Attorneys Association supported the bill. And so it had wide bipartisan support, but just didn't make it to the finish line back in 2018. And as you all know, Maryland currently has only two degrees of assault. Assault in the first degree, which is a felony, carries a maximum of 25 years. There's no fine associated with that. Assault in the second degree, which is a misdemeanor. And assault in the second degree covers a wide range of actions, such as throwing a water balloon at someone, all the way through to punching or smacking someone in the face, something more serious conduct. Assault 2 carries a maximum penalty of 10 years. And up to a $2,500 fine. And that's where our discussions centered last year about how wide a variety of the conduct was within Assault 2 and some of the collateral consequences that are born out of having a statute with such a wide berth of conduct. And I'm sure that our panelists will talk about some, maybe even the immigration consequences, some of the consequences for firearms ownership and the like. It's, again, important to understand that there's no distinction for a lesser penalty for the types of assault that are less severe, like non-injurious offensive conduct. So Senate Bill 514 allows for this distinction by creating assault in the third degree. Creating assault in the third degree will allow for the distinction between less harmful incidents and more serious cases, both of which are currently lumped in, as we discussed, to that second degree assault statute. So what the bill does, it establishes a third-degree assault category to allow for further distinction between more serious conduct subject to the second-degree assault charge and less serious crimes that would now fall into this category of third-degree conduct. It would provide for a lesser charge for a person who would otherwise be charged with second-degree assault. So currently, for example, someone who shoves another person who would be charged with second-degree assault and face up to 10 years and $2,500 could now fall into that third category, which under this bill is a 90-day misdemeanor, I think up to $1,000 of a potential fine. It defines offensive conduct as non-consensual physical conduct that a reasonable person would find to be offensive. It's also important to note that this bill does not include conduct that results in physical injury. It doesn't include conduct or contact that causes risk of serious physical injury. It does not include domestically related crimes defined under Section 6-233 of the Criminal Procedure Article, and it does not include a sexual crime under the subtitle 3 of this statute that we're proposing today. Again, it creates that third-degree assault charge. 90 days, and I'm sorry, I misspoke, it's a maximum of $500 fine, but it's a misdemeanor, and then this third-degree assault charge category would be eligible for expungement under the statute. So with that, understanding a little bit of the legislative history between going from 4 degrees of assault to 2, the wide array of conduct that is associated with the second-degree assault charge, and the collateral consequences that are associated with something as minor as a shove for immigration or for on one side, and for potential gun ownership and right to carry on the other side. And in the interest of justice and in the interest of understanding that this issue has been studied for a number of decades in the General Assembly, I respectfully request a favorable report. I'll turn it over to my panelists and then stand by for questions.
Thank you, Mr. Chairman. Good afternoon, Vice Chair Wallstreicher. My name is Brian Shefferman. I'm the current president of the Maryland Criminal Defense Attorneys Association. This Senate Bill 514, we ask for a favorable report. As Senator Smith just informed you, we currently, under current law, there's two categories of assault. First-degree assault is a felony and has a maximum penalty of 25 years in jail. And that is a crime that the element is that it covers conduct that when a person is charged with intending to cause serious physical injury. It also includes strangulation, which is been in the law for a couple of years now. It also includes assaulting with a firearm. And that is a crime that we have that covers the most serious types of assault. Second-degree assault covers everything else, as the Senator said, including minor pushing, shoving, or whatnot. I think one of the main reasons that we support this bill is that it is consistent with the principle that a maximum penalty for a crime should fit the conduct in question. So this bill is a very limited bill in the sense that it does not include any conduct whatsoever that would result in injury. It doesn't include domestic violence cases. It doesn't include any risk of serious physical injury. It is only for the least serious types of assault. And we ask for a favorable report because, again, it will create a situation in court where the state's attorney, it is important to note, has the final discretion whether or not to even bring this charge. It is not a lesser included offense, and therefore it gives the state's attorney the discretion whether or not to pursue this type of charge. So Ms. Dufour is going to follow up with some other reasons why we support this bill.
Thank you for bringing this bill, Mr. Chair. Mr. Vice Chair, members of this esteemed committee, my name is Christine Dufour. I'm the immediate past president of the Maryland Criminal Defense Bar Association, and I'm here to ask for a favorable report on SB 514. In my written testimony, I outline a couple of examples as well as the impact of Second Amendment impact and non-citizen impact. So the one example I gave was a client I had about a year and a half ago who is intellectually disabled, lived out of his family's home in a placement, and his peer-to-peer worker was telling him to finish his lunch, and he was getting frustrated that he was being told to finish his lunch because he didn't want to eat right then. He threw a plastic utensil at the peer-to-peer support worker who was assigned to him. She knew what his buttons were, if you will. She went to the commissioner and filed a citizen-generated complaint for second-degree assault. While my client was competent to stand trial and we went through the process and the charges were ultimately dismissed, the amount of stress it imposed on him caused him to compensate because he couldn't appreciate that he wasn't going to get 10 years in jail if he was found guilty. He was competent to stand trial, but he couldn't appreciate that he wasn't going to face 10 years in jail. With that, I would tell the body that Second Amendment impact includes second-degree assault for public safety purposes is considered a crime of violence, which means people can be prohibited from owning guns if they have a second-degree assault on their record. I'm from the Eastern Shore. My husband hunts. My neighbors hunt. It would be very impactful if they were unable to do so because they were found guilty after shoving someone in a bar. Finally, non-citizen impact. Under the federal immigration law, the classification of offenses as misdemeanors or felonies is primarily based on their maximum sentences. The fact that misdemeanor assault carries 10 years in jail impacts the ability of the non-citizen to pursue citizenship on a lawful path. With that, I'll welcome any questions.
Thank you for your testimony. Senator James.
Thank you, Mr. Chairman, for bringing this bill because it actually helps with my forfeiture by wrongdoing because that involves second-degree assault. One of the minor but important criticism has been that because second-degree assault goes from very serious, which is what we're aiming at, to the very minimal, not just minimizing, but minimal touching. This would also greatly help that effort. And it also helps because, as Senator West often points out, we have a big commission trying to modernize our criminal law because it really is out of whack by title sometimes, offensive, between felony and misdemeanor. We have misdemeanors at 10 years, just second-degree assault, up to 10 years, which seems like it should be more of a felony. So this is just one great step, I think, in improving our criminal laws. Isn't that, don't you think so too, Mr. Chairman? Don't you think it helps my bill? Thank you.
Senator Folden and then Senator West.
Oh, okay. Thank you, Mr. Chair. So I just thank you for bringing the bill. Obviously, this is something I think we've discussed in the past, but I just want to point out to everyone that, we always talk about the bar fight or something like that. That's pretty, not minimizing it, but these people, it's unfortunately what happens at times. But I want to go even a step further. I want to say, by law, by definition, a second-degree assault is any unwanted touching. So if I go and put my arm across someone to move by them, by the law, and I move them aside, have I committed a second-degree offense or second-degree assault?
I believe there still is an element of intent to cause offensive touching, even if it's general. Spitting on someone.
If I go up and poke somebody in the chest with my fingertip,
Arguably, that could be.
that is second-degree assault.
If it's unwanted and perceived as offensive and unconsented.
Thank you.
Thank you, Mr. Chair. I guess, let's talk. No, you. And if we can't figure out the answer to my question, then we'll go to the sponsor of the bill. I'm trying to figure what some examples of second-degree assault and then third-degree assault under this bill. So the sponsor mentioned water balloon. So if I throw a water balloon at someone and it explodes and covers them with water, that would, in your view, that would be a second-degree assault.
We would argue that it could fall in the category of third-degree assault because there was no intent of serious physical harm. There was no punching. There was no contact other than just throwing the balloon, which caused someone to become wet. Included in what we would believe conduct that would fall under third degree would be spitting on someone, shoving someone, as Senator Folden just said, aggressively pointing someone's chest, which was unconsented to and considered offensive. So I think there's and it would give the prosecutors, as Mr. Shefferman said, broad discretion as to whether or not to even pursue the charge because it's not a lesser included offense. So, but it would also encourage, I believe, resolution in district court because it's not available to the client to have a jury demand if it's a 90-day offense. So hopefully cases would be resolved in district court as opposed to kicking it over to circuit court. I know some of my partners in our association don't agree with that, but we think and agree with the sponsor that that was the best outcome at this juncture. With regard to additional conduct, I think you can also plea bargain down. If there was a punching fight, but there was no injury ultimately, I think it's up to the parties to say whether or not, we do that all the time in plea bargaining. It might not fit the facts of what we ultimately plead to if we were charged initially with that, but we do all the time. We'll negotiate pleas from a first degree to a second degree. Even though a gun might have been used, we might take a second degree offense, assault. So I hope that answers your question.
It's helpful. Let me, I guess, pursue it in this way. Is it conceivable that the state's attorneys would find that third-degree assaults are unworthy of their time and attention, and when something would fall in that category, would simply say, well, we don't prosecute those, and therefore, in effect, turns third-degree assaults into offenses which simply are disregarded by the lawful authorities?
Well, I don't know that the penalty would avoid the prosecutors pursuing conduct if they felt they had a meritorious claim. And I would note that, they pursue driving while without licenses, which is a 60-day offense routinely on the Eastern Shore. So that's whether or not there's an accident. So there are offenses in that category of 60-day, 90-day offenses that are pursued, but it would be certainly at the discretion of the prosecutor to decide whether or not to charge as a second degree or third degree.
Okay, let me just give you an example. A couple of years ago, I was standing outside the polling place in early voting, and a woman came and asked whether I was a Republican or a Democrat, and I answered honestly, and she hauled off and slugged me in the stomach. I was wearing a ski parka, one of those old puffy ski parkas, so her hit didn't hurt me at all, and she turned and stalked and went to the polls, and I thought of calling after her. I guess that means you're not going to vote for me, but I didn't. But if I had gone to the state's attorney, if this were the law and I'd gone to the state's attorney at the time, I assume you would say that what happened to me would have fallen into the category of a third-degree assault.
I think it would straddle the line because it was a punch. It was a closed fist punch.
Yeah, but it didn't hurt me. There was no injury.
Right.
My ski parka insulated me.
Right. Yeah, sure. I'm going to turn that over.
Could I just comment on your question? So that would clearly fit, a second-degree assault, and it, as Mr. Ford said, that could clearly also be a third-degree assault. The prosecutor could make a decision, under this bill, would have the absolute right, in consultation with the alleged victim, to make a call on that. Just a quick comment about your other question. I don't think it results in fewer prosecutions at all. There was some concern it might result in more. Because as it stands now, there are some assaults that occur that, as you indicated, even if a complaint is made, the prosecutor just decides, you know what, I just don't really feel like this is worthy of bringing it into.
I've got bigger fish to fry.
I'm sorry?
I've got bigger fish to fry. I'm too busy, that kind of thing.
Well, yes, that could be part of it, or it was just so de minimis that even though, yes, I could possibly prove this case, it's not worthy of prosecution, and so they enter the case non pros, and yeah, they make that call all the time. And so that this option of being third-degree assault, frankly, I think there's some concern among the bar that instead of dropping it, they will. Some people have some opposition amongst defense attorneys that it will possibly lead them to say, oh, well, let's just make this a third degree. So if anything, I think the answer to your question is it might go the other way.
I got you. All right. Thank you for your answers.
Senator Henson and Senator Love.
Thank you, Mr. Chairman. May I ask you a question, sir?
Sure.
You mentioned in your testimony that it is not a lesser included offense, and I see that included in the text of the bill. Can you talk me through the rationale there?
Well, I think that was put into the bill apparently to satisfy some concerns from the State's Attorneys Association, because they were just felt that somehow that would, if it was in fact lesser included, which I think but for that being in the legislation, there's a really strong argument that legally, as far as the elements lining up and being the same, it would in fact be third degree assault would be lesser included of the second degree. So this was put into the legislation to take away that concern that the prosecutors had. And so it's giving them this discretion to either to just simply not charge it, not prosecute the third degree, and just say, no, we think this should be a second degree. So I think as a practical matter, it ends up this is going to end up being something that will get negotiated in court, and a prosecutor and defense attorney will say, well, I don't want to, plead guilty to second degree. Will you give me the third degree assault conviction? But I'm not sure if that answers your question or not.
It does, kind of. So are you saying that a person wouldn't be able to plead down if it's expressly prohibiting it being included as a lesser offense?
It means that if it goes to trial.
Okay, if it goes to trial.
In a plea bargain situation, absolutely, no problem. You can plead if there's an agreement reached between the state and the defense. The third degree assault would be, the defendant would plead guilty to that lesser offense, third degree. At a trial, it would not be an option from which the judge or jury could find you guilty unless the state basically leaves it in there. If the state chooses to, in other words, if they didn't want it to be lesser included, they essentially would have the discretion to either simply not charge it or null pros the charge before trial began. Is how it would sort of work out in court.
The option you spoke about, that in a negotiated plea agreement, that the state and the defense could negotiate for the third-degree assault instead of the second. Do you think the language we have in the text of the bill, unless specifically charged by the state, assault in the third degree under 3-203.1 of this subtitle is not a lesser included crime of any other crime? Do you think it's sufficient for that scenario that you laid out of the negotiated plea agreement?
Yes, absolutely, because it's a standalone, it's still an offense that stands alone. It would not in any way, I can't imagine how it could possibly impede a plea bargain that would allow the defendant to plead to third-degree assault as long as that was the agreement reached between the state and the defense.
Okay.
It would only really come into play when there's if there was a trial.
Does that language in any way exclude if the resulting charge is from a civilian complaint?
No, if the civilian goes in and the commissioner decides to put on a statement of charges second-degree assault and third-degree assault as well, it's now up to the prosecutor, frankly, how to handle that in court. If they want to, if there's a trial and this assistant state's attorney leaves that charge in there, then as I read the bill, then it could be argued that the third-degree assault would be lesser included.
Do we, okay. I was struggling to try to figure out as well if we have the full autonomy to make that sort of statement in the text of the statute, understanding that there are some jeopardy implications when it comes to lesser included offenses. So if we are prohibiting it from being a lesser included offense, but a person is charged with second-degree assault, but they believe, or the facts flesh out, that the person was not injured.
Right.
And now they don't qualify for it to be a lesser included offense based on what we've put it in the statute expressly. And so there may be some constitutional implications there. How are we squaring that when it comes to the constitutional implications of prohibiting lesser included offenses?
The Supreme Court case law, from Maryland and the United States Supreme Court has made clear that legislators, by statute, the legislature can essentially dictate what is and isn't a lesser included. And a good example would be the crime of use of a firearm during a crime of violence. That, under the what's called, the Blockberger test, was absolutely be a lesser included offense of, let's say the person gets charged with armed robbery and they're using a handgun during the armed robbery. So in that situation, you're convicted of the armed robbery and this charge of using a firearm during a crime of violence, which has a mandatory minimum penalty of 5 years without parole. That would, in fact, merge normally under the required elements test. That would the firearms charge would merge, but of course the statute says no. This shall be consecutive. The legislature has specified that it does not, and courts have upheld that authority of essentially the legislature to make a crime that would otherwise be lesser included. The courts have allowed legislatures to essentially say, no, we've decided that this shall stand and it will not merge. So I don't think there's a constitutional problem with it. You could try to make the argument, but it shouldn't succeed. Because that argument has absolutely been made with respect to the mandatory minimum, the use of a firearm during a crime of violence. And Maryland courts have squarely rejected that and said, no, it's not a double jeopardy problem. You can get sentenced on both separately.
Thank you. Also, I was trying to, so some of the language in the bill, I'm trying to figure out how broad it is. There is a person may not engage in conduct to put another in fear of offensive contact. Kind of looking at that portion there, just trying to flesh that out. So I have legislation outside of this one, obviously, that deals with doxing. And so the part of doxing that gets you to being able to restrict people's speech, because typically you can't, is with a nexus of harm. And so I'm looking at that, engaging in conduct, intending to put another in fear of offensive contact. Could it be an element of doxing? Let's say I release someone's personal identifying information, and what I'm intending to do is to have people harm that person, and that's why I'm telling you where they live and what they've done and why you should be angry with them, because my goal is that you go and harm them, and that's why I'm doing that. Would that be included in the engage in conduct intending to put another in fear of offensive contact?
I think it would be a really tall order for the state to prove that, to make that fit. I guess on any given factual set of facts, it may be possible.
What's the perfect set of facts for that?
Right, but it would seem that the anti-doxing law would be the way to.
Sure, would be better suited for that because it's express. But I was wondering what fits that element, what fact pattern would fit that one specifically? Like what's the kind of the ideal scenario that is engaging in conduct intending to put another in fear of offensive contact? Like what's the classic scenario?
So, I mean, it's so there's this whole, of course, common law body of assault law that would still be used to interpret, I think, first, well, really second and third degree assault. And this, the sort of, the phrase offensive contact has judicially determined meaning. And so I think there's lots and lots of cases that discuss that. And it's normally in the context of like words alone are not enough to support the offensive contact required for an assault. So I would think it would be, I can't imagine a prosecutor trying to use this to shoehorn in, that where you're making a verbal, or taking, using the internet to, like you said, to dox somebody. It would be highly unlikely that they would.
Can you give some of those common law examples, like saying something and they're like got a fist?
Right, so. Well, the case law talks about going all the way back to England, just threatening someone. I'm gonna get you. Is not sufficient. It's got to be imminent. For assault, it has to be the harm has to be imminent. So I think there'd be such a big gap in the scenario you're talking about, the doxing, that it would be very hard to fit it under the meaning of, the judicially determined meaning of assault, intent to cause contact. Okay. So it's usually got to be words coupled with some action.
Okay.
Raising and the person also has to have the apparent ability at that moment to cause the contact. Okay. So if I'm on the other end of if I'm on a phone, for example, I can't assault you. They might be guilty of some sort of harassment by phone, but it wouldn't be an assault. It wouldn't. I threatened to hurt you. That wouldn't be an assault. Okay. Because I don't have the apparent ability. I can't do it. Can't accomplish it.
Okay. And then another, and I think you may have touched on it in your response, but I wanted to make sure that decoupling the third degree assault from the second degree assault, I think that the second degree kind of drags the curve up in terms of the seriousness of what needs to happen in order for someone to be charged and convicted, whether it should or should not, because harmful or offensive means harmful or offensive. So offensive should be included. So,
right. So
may I finish?
It's still.
May I finish?
Oh, I'm sorry.
That's good. So harmful or offensive should be included. So everything that should be included under this bill should already be a violation of the law. But when you decouple the two things and you have a standalone for offensive conduct that does not injure, I just want to make sure that we are not, that the curve is not being disrupted in a way that we are not setting a bar so low that offensive conduct is now not going to open the barn door for everything to now become a crime in terms of the contact with people to people. So just, can you give me your perspective on, you touched on the body of case law, how far it stretches back, how well fleshed out this is. Can you give me your perspective on how that is not going to happen?
Right, because I don't think in any way this expands the definition of assault, and any form of assault. It's still absolutely requiring offense, the way it's drafted, the intentional cause, it's only prohibiting, or is prohibiting, intentionally causing offensive contact, engaging in conduct, intending to put another in fear, attempting to cause offensive contact. And these really are those are taken from the sort of 3 different ways a person can commit what we used to just call like assault and battery. You know, before there was even the second-degree assault statute came into being. Those are the 3 ways that a person could commit an assault. So this is, I think, in no way, shape, or form changing or making any conduct that was non-criminal before, and now somehow this is making it to be criminal.
I appreciate your response. May I ask a question of the sponsor? Mr. Chairman. Last year when we heard this bill, one of my concerns was the element of discretion, and that we know we have a lot of implicit biases embedded in our criminal legal system, and wanting to make sure that we weren't setting up kind of a system where some folks could get the benefit of a 3rd-degree assault charge, and some folks in a scenario were getting the benefit or were getting penalized with a 2nd-degree assault charge if it were the same fact pattern, that if an officer were responding, we weren't getting disparate charges for different people. Do you feel like with the summer study and the work that was done and the changes from the bill this year and last year that you fleshed out some of those, some of those opportunities, and do you feel like we've gotten to a good place with that?
Sure, yes. We talked about this before, that like the element of bias is kind of, there's a risk to that with any piece of legislation that has gradations of fines or terms of imprisonment. So there's always the risk there. I think that with a lot of the work that we did in police reform and to ensure that there's implicit bias training and the training that the Judicial Conference does, that there are safeguards there, but is the risk there I think that's going to be present through any piece of legislation that we pass. We can just make sure that we're doing the back end work to make sure that we're addressing implicit bias and then all other forms of bias.
I appreciate that. Thank you. Thanks, Mr. Chair.
Mr. Chair. Mr. Chair.
Yes.
Yes. The Women's Law Center and the state's attorneys raised concerns about the impact this bill would have on survivors of domestic violence and sexual assault. I don't know if you've had a chance to see their opposition.
I did.
Great. So would you like to comment on their concerns?
Sure. So I squinted toward this during the testimony, but and I don't know if this meets the mail for their concerns, and I defer to the practitioners here, but it does not, domestically related crime, it does not include that. It does not include a sexual crime under subtitle 3 of this article, but also domestically related crimes. I think that helps to meet their concerns. I know that there was an amendment there to, I think it was to turn them into all these into a 14-101 crime. I think they had an amendment there. Dorothy Lennig may have had not Dorothy, but Ruth may have had an amendment for that. But I don't understand the full scope of their concerns, and I don't know if this meets their concerns. I'll have to address that offline with them.
Okay, thank you.
But I am aware of them, yes.
Thank you.
Any further questions for this panel? All right, thank you, Mr. Chairman. If you have other supporters of the bill that we can bring
No,
them.
I think it's just the opposition.
Oh, okay. Mr. Katz, are you opposed to the bill? Come on up.
Mr. Chairman, members of the committee, my name is William Katz. I'm an assistant state's attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 514. Back in I thought it was 1996, Chairman indicated 1995, there was the assault revision panel, which took up the issue of assault. assault had been a common law crime, as assault and battery, with a common law penalty. Well, they took it up in, I think in 1994 and 95, that unlike arson and burglary, which had been revised in 1 year, assault did not happen the first year. As a matter of fact, there was 4 different categories of assault, but I didn't think it made it the first year. I thought it had to come back the second year, and that's when the law was actually, the bill was passed. So it's been 30 years. I have been in the office a lot longer than that, been prosecuting crimes a lot longer than that. I don't see where there's been any particular problem with the current law, such that it needs to be amended or needs to be changed. Under existing law, first-degree assault involves either a general intent assault involving the use of a firearm or a specific intent involving a situation where somebody commits an assault with intending to cause serious physical injury. A serious physical injury is defined in the statute. It basically is taken from the old maiming law, so it's pretty serious stuff. And then you have everything else, which is second-degree assault. There are no mandatory penalties. It's up to 10 years, but a judge has absolute discretion as to what the penalty should be. And I can tell you, bless you, I can tell you in many instances, second-degree assaults result in probation before judgments, or if the conviction stands, with a relatively minor penalty. It's not like a first-degree assault prosecution. When I'm not here, what I was doing earlier today, and I will be doing when I get back, I screen felony assault cases. I either keep them as felonies and prosecute them in circuit court, or I determine that it's not enough for first degree. I think it should be second degree. I have the first degree null pros and send it back to district court. There's absolutely nothing that's wrong with the current law that it requires any significant change or the elimination of the existing law. I would urge this committee to give the bill an unfavorable report.
Thank you for coming in and sharing that. I'm favorably disposed to the bill, but you know, obviously when the state's attorneys speak, I listen. Do other states have just the dichotomy of first and second degree, or do states have third?
Oh, there are states that have all kinds of different laws. Okay. Some of them have different categories of misdemeanors, a first-class misdemeanor, second class. Same would apply with the felony.
Let me ask you this. I do have an important bill about second-degree assault, because currently it's excluded because it's a misdemeanor and not a felony under the forfeiture by bad acts of the defendant, right, when somebody intimidates a witness. And this committee has been very supportive, but I do have to go over to the House. And one of the critiques of it is, look, you know, you're ensnaring also these low-level assaults, and you're maybe cutting off a defendant's right to confront. Not that I buy into any of this, but it is sort of like there's no nuance and no distinction. It's a very broad assault charge from really serious. I mean, some of the most serious assaults you can think of would fall under second degree, all the way down to an innocuous, unintentional touching, you know. So let me just what is it about breaking that apart and clearly making 1 second the more severe, what people generally think of, and the offensive touching? Give me the crux of your opposition. Or, in other words, why would you be against my feeling that, in my personal feeling, that having those two distinctions just gives states attorneys more ability, flexibility for settlement, for charging, and more flexibility with defense and defense counsel? So,
well, let's put it this way. I don't see, if the issue is up for grabs, I'm not sure exactly how we would essentially feel. Okay. But we do have a law, and the question is there any compelling reason to change the law? Right. I can tell you when it comes to assaults, obviously there's a a significant area between the most serious and the least serious when it comes to second degree.
Right.
But part of the problem also is first degree is at times very, very difficult. Okay, if it involves a firearm, that's not a problem. If it involves an intent to cause serious physical injury, it's intent to cause serious physical injury as it's defined by the statute. That's the old maiming law, which essentially is to disfigure somebody.
Right, right. You just mentioned. Well, that kind of begs the, or also dovetails to this large committee that you're probably aware of that is looking at the criminal code, because we are an outlier in many areas, right? Not to mention, I don't know this for sure, but my gut reaction is an assault that can get you 10 years sounds far more like a felony to me than it does a misdemeanor. So that's just an oddity where we would have penalties that large, but still define something as a misdemeanor. Maybe, you know, I'm not a criminal lawyer, I'm a civil lawyer. So you're bringing up a good overall problem that we have, that we need to modernize and make our criminal law more consistent. I think we're both on the same page there.
The issue with the penalties is the fact that a lot of states adopt what the feds have, and that is that anything over a year is considered to be a felony.
Right.
Okay.
Well, I'm not going quite that far. But
Maryland, obviously, we have perjury is a 10-year misdemeanor.
Right.
Okay? Bribery is a misdemeanor.
I know.
Carries up to 10 years incarceration. We've never necessarily looked at the category of the crime. We looked at the severity of the crime and what the appropriate penalty ought to be.
Right. Well, but again, that long a penalty, that much deal, that's pretty serious to me to still define it as what I understand a misdemeanor to be. But thank you for sharing. You know, we'll certainly take what you had to say. Thanks.
Thank you very much.
All right, that'll conclude the hearing for Senate Bill 514. We'll now move on to Senator West with Senate Bill 631.
See, you sit back there all afternoon. Good to see you. Thank you, Mr. Chair. It's a pleasure to be here to present the annual bill, the Miscellaneous Corporate Law Changes Bill, that is brought to us each year by the State Bar Association's Business Law section. As you probably know from my testimony in prior years, before I ran for public office, I was a member of the Executive Council of the Business Law section. So I've known Bill Carlson, who's sitting to my left, for probably 25 years because we've worked together so well. Each year, I hope you'll recall, the Business Law section has a very active legislative committee which goes through our extensive business laws and tries to find sections of the laws that are either unclear or out of date or have a little glitch in them that we need to change, and also other laws that would enable Maryland to take its place as one of the leading business law states in the country, which would prevent us from losing corporate incorporations to other states like Delaware, which does annually update their business laws to remain state of the art. So Maryland has done a great job over the years in trying to make sure that here in Maryland, our laws are up to date with Delaware's laws, so we do not lose business to Delaware. Every business that incorporates in Delaware as opposed to Maryland represents a loss of income for the state, and sometimes businesses that incorporate in Delaware decide to relocate in Delaware as well. So it's important that we keep our business laws up to date. So this year, we have 5 components to this bill. Again, it's a miscellaneous bill. None of these changes are world-shattering. All of them are recommended. So change number 1. Under current law, businesses may face uncertainty or delays when charter documents are rejected by the State Department of Assessments and Taxation. This bill addresses this issue by requiring SDAT to notify filers if a charter document is rejected and provide an explanation for the specific reason for the rejection. And the bill allows the charter documents that are corrected and then refiled within 30 days to be recorded as if they were filed on the original date. Simple little change. It's going to make a lot of difference to anybody who fails to do some modest comply with a modest requirement when recording an important corporate document. Secondly, the bill clarifies when corporate boards and committees of the 40 Act investment companies that are open-end funds may take action without holding a meeting, provided there is a consent of a majority of the entire board and given either electronically or written. This change better accommodates modern business practices and ensures that investment funds can maximize efficiency while maintaining appropriate safeguards. If some member of the board dissents, the dissenter has an opportunity to register the dissent on the records, the corporate records, even though the dissenter was outvoted because the majority of the board decided to make the change. Third change, this bill updates provisions relating to bankruptcy and receivership to explicitly authorize trustees and receivers acting under federal law to carry out corporate actions necessary for the federally approved reorganization. This ensures consistency between Maryland law and federal bankruptcy proceedings. Fourth change, modest one, if a foreign corporation fails to qualify to do business in Maryland and therefore can't sue, under current law, the fine is $1,000, which seems excessive. We want foreign corporations to comply with our law, and therefore this would reduce the fine to $200, which is much more appropriate. It's not a mortal offense to fail to do something like qualifying to do business in Maryland. It just, once remedied and a modest fine is paid, then the foreign corporation is in good standing in Maryland and can avail itself of the use of our courts. And then finally, the fifth is for limited partnership agreements. This requires the unanimous consent of the limited partners in order to amend the limited partnership agreement. That's something which is now part of the recommended Uniform Limited Partnership Act, but a part of the statute which Maryland has not yet enacted. So we're enacting this now because it's an important change. So with these changes, there are only 5 of them. All are modest, but all will be important in particular circumstances. The statute, rather the bill, would offer flexibility, clarity, and fairness within the state's existing corporate framework and would foster a predictable and business-friendly legal environment while maintaining appropriate oversight. As I indicated earlier, Bill Carlson is with us, and he knows these changes inside and out. If somebody has complicated questions, please address them to Bill, and I'll give the proceedings over to Bill in the meantime for him to further explain the nature of the bill. With the hope that when the bill is all said and done, that you all will favorably endorse the bill. Thank you.
Thank you, Senator West. Good afternoon. Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. I'm Bill Carlson, Chair of the Committee on Corporation Law. I'm here for my 10th time before this committee. I can't believe that. In any event, Chris ably described the 5 amendments. I'll just hit upon a few of them and to kind of supplement. The bit about creating a statutory process for resubmitting rejected charter documents and providing for certainty as the effective date. Right now, there's a very informal kind of process, and lawyers like me who actively practice corporate law know who to call, how to deal with it, how to get it done, say, please give me a return effective date. And we really want to put in the statute so there's uniformity, not just me, but everybody can do it, and it's in the statute for that. And getting the original effective date is important. You want to dissolve the corporation on December 31 and end it then and not continue for another year. You have a merger date, 2 businesses joining, it's going to be June 20th or whatever date. Employees change over, certainty about effective date. On the bit about the bankruptcy law, right now our Law 3301, for whatever reason, I lost a history. I should have hired Senator Smith's historians or whatever, says that a trustee in a bankruptcy of a Chapter 11 reorganization doesn't need board approval to do things the bankruptcy court orders him to do and can sign charter documents. And for some reason, a trustee in a Chapter 7 liquidation doesn't have that same power, when often in Chapter 7 liquidations there are no board, there are no directors, there are no officers, and it's kind of created some complications for that. And with those 2 additional comments, I'm happy to answer any questions.
All right, thank you very much. Senator Sidnor.
The first question, Senator West, you said something about a second change, and I'm trying to figure out where that is.
Second change?
Right. The Second Amendment, you numbered 1, 2, 3, and 4, and I was trying to figure out where these things are in the document.
The second change is on page 3 of the bill, and talks, this is the one about the.
Want me to try to answer that?
So it's not unanimous, it's not a unanimous written consent.
So the first one is 1201 on the first and second page of Senate Bill 631, and that deals with the refiled charter documents.
Okay.
2408, which is the second and third and fourth page, that is the bill that talks about having a softer written consent requirement for boards of directors of 40 Act corporations that are open-end funds, a T. Rowe Price mutual fund, for example. And they may have 18 directors. So it's a narrow change for 2408.
My question to there is why would you want it limited to those types of corporations if you may have other companies that may have similar issues?
Yeah, as a corporate lawyer, I think it's important for the board of directors to be held accountable for their actions and have the opportunity to have genuine debate. So most corporate actions occur at a meeting that's duly called, that a quorum is present. Maybe everybody doesn't show up, but a quorum's present, and there's active debate and resolutions, and they're passed. And the exception to that is you can have a written consent where all the directors, there's unanimity.
Unanimous written consent.
And so that's a standard process, and I think it's one that is good for corporate governance for a Maryland corporation. It's a tough standard, but if you don't have unanimity, call a meeting and have it out among yourselves. So this is a narrow exception requested by the mutual fund industry for registered investment company acts.
I was trying to figure out why it was just for this type of
they may have 18. These mutual funds are often, this is a simplistic assessment, but they may have 10 funds, each of which have 18 directors, and calling meetings and everybody's showing up and having written consents, and one person's on vacation, and it's an accommodation to them that was requested. I'm not giving away who it is, but there's a letter by T. Rowe Price requesting this, but which they could accomplish the same thing by no longer having their funds be Maryland corporations, but going to Delaware statutory business trusts or other things. So we think I'm comfortable with a narrow thing. I would not be comfortable with saying all corporations could do this, because I think the directors need to get in a boardroom and have a debate.
Right, because again, as you noted, you can have a unanimous written consent in lieu of meeting, but that's unanimous, but this would allow for it not to be unanimous?
For mutual funds, open-end funds that are registered.
For a small segment of corporate entities in the state.
Yeah, they're federally registered funds.
Okay. And the last question is, Senator West talked about the fine. I guess it's on page 6, lines 3 through 7 that's being struck. I mean, is $1,000 that much money for a corporation like this?
Well, so I want to kind of maybe clarify what this actually does.
Okay.
Right now, so first off, when a corporation's not from Maryland and they're conducting business in Maryland, whether they're required to register or qualify in Maryland is often kind of like when you see a test.
Right.
There's certain exceptions, but a lot of times people, they don't really know they should or shouldn't, and you can call 10 lawyers and get 10 answers. So sometimes it's a little unclear. So there is presently a $200 fine for corporations, and that continues unchanged. What we're proposing to change is it says that any and all officers of these corporations and any and all agents, I don't even know what agents means, the real estate agent, the person answering the customer service phone, I mean, any and all agents and any and all officers can have a $1,000 fine. And it struck us that it's appropriate to have the fine on the corporation, and the corporation has other reasons why they're going to want to register. They can't bring lawsuits in Maryland, things like that, which will impinge what they may want to do. But any and all officers, any and all agents, I don't even know what the word agent can mean. I thought that's what we're trying to take away is the $1,000 fines on people. I mean, a company could have 1,000 employees. Are they all 1,000 agents and they all get a $1,000 fine? I mean, it struck us as kind of a little aggressive.
So if it was modified to strike agent and just left to the officers, would that be problematic?
Well, some companies they could have dozens of agents. I mean, I think it's,
Let me ask you this.
excuse me, agents and officers, excuse me,
Right.
agents and officers. And I asked General Counsel at SDAT, and I also spoke to Director Yeager, like, do you use this?
Right, how often is it
And their
used?
answer, no, we've never used it. In which they said, well, why don't you just leave it? And I'm like, well, it strikes me as being just horrendous that you can, I mean, it's kind of actually just a little chit chat among lawyers in the country. Like, Maryland, if you don't obey their rule about foreign thing, other states don't do this. All your officers can have a $1,000 fine.
Right. Mr. Chair, can I ask one other question? And I ask because of your expertise in this area, and it's a little off of the bill, but it's not. Since we're dealing with business entities, I'm not certain. Are you aware of something called the return to land strategy?
I'm not, no.
So it's a strategy that these white nationalist organizations are using in the Midwest, where they're using corporate legal entities like LLCs and private membership associations, and claiming that because one owns an ownership stake in a company, rather that they're not subject to things like the Fair Housing Act, so they can outwardly purchase property and thumb their noses to fair housing laws. Just out of, do you have any experience with fair housing laws and people reading corporate laws in that nature as a way of kind of shielding themselves from civil rights laws?
I did not have experience with that. I remember some of I forget how it's expressed. There was all this like sovereign debt things that were happening. People were putting UCC statements against Governor Schaefer. So I'm kind of familiar that people have a little mischief sometimes with corporate laws and Uniform Commercial Code, but I'm not familiar with that.
Okay. Thank you. I appreciate it. Thank you.
That was definitely the right answer. All right. All right. All right. Seeing no further questions, thank you both very much. Good to see you.
Thank you.
All right.
Thank you.
Senator, thank you. All right, with that, that'll conclude the hearing for Senate Bill 631. We're now going to Vice Chair Waldstreicher with Senate Bill 516.
Thank you, Mr. Chairman. This bill will be pretty straightforward and easy. You go in a grocery store, everything has an expiration date in the grocery store. We talk about milk, most obviously, but really everything has an expiration date on it. The expiration date doesn't mean that the thing that you're buying is going to be bad necessarily after that expiration date. But what it means is that the company that's making the product that you're about to buy in the grocery store is essentially guaranteeing it up until that expiration date. So you buy milk and you buy it at the expiration date. The next day, it could be fine. The next day, it could be bad. You don't know. And you don't want to take that risk with milk or really with any other product. The same goes for body armor. We have jurisdictions in the state of Maryland that are providing body armor to our law enforcement officials that is beyond the expiration date. Will it work? Maybe. But we don't know if it will or if it will not. And it's disrespectful to the law enforcement officers who risk their lives that they go out with this risk, that they're not sure that the body armor that they've been provided will provide the guaranteed armor that it should had it been before the expiration date, where the manufacturer can indicate its level of safety. And so that's all the bill does. It provides that all body armor issued to our law enforcement officers must not be expired, and then provides guardrails to ensure that that happens. With that, Mr. Chairman, I'll ask for a favorable report for Senate Bill 516 and turn it over to my witnesses.
Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police. This piece of legislation we think is a common sense piece of legislation to make sure that our law enforcement officers are protected when they go out on the street. I can't tell you how many times that I've gone to Maryland Shock Trauma and met with Dr. Scalia down there, who does an amazing job with saving the lives of everyone that comes to shock trauma, but particularly our police officers who were shot in the line of duty. And there have been a number of occasions where I've been there and greeted families and saw that the officers, only reason that the officer had survived their injury is because of the piece of body armor that worked as intended. Just a quick story. I didn't know that this was still happening 25 years ago, later, but when I first got out of the police academy, my police department did not issue bulletproof vests because it was not a requirement. And my police department went to the Maryland, my old job, went to the Maryland State Police and got a bunch of vests that were, I guess, expired and told us, hey, if you guys want a vest, you have to sign a waiver that if you're shot in the line of duty, that the agency is not responsible. And so thankfully, this was the first piece of, I guess, union type work that I dealt with in my young career. We were able to find and secure grant money to pay for half of the vest. And so most agencies across the state of Maryland use grant funding, such as the COPS grant and other grants, to purchase body armor at a significantly reduced cost. And so what we're simply asking with this piece of legislation is that agencies are keeping track with when an officer's vest is going to expire and make sure that they order the vest in a timely manner so that they can have them at the time that they expire. So we urge a favorable report. Thank you.
Good afternoon, Chairman and committee members. I'm Lieutenant Elliot Cohen. I'm here on behalf of Baltimore City FOP Lodge Number 3. This legislation is an important block in keeping officers safe, ensuring that they have the tools they need to keep communities safe. The bill requires agencies follow accepted manufacturer and National Institute of Justice standards without imposing significant costs. Law enforcement agencies in the state already have internally accepted that protective body armor should follow NIJ and manufacturer standards, and that body armor should be replaced in a timely manner. However, there is no mechanism to force agencies to follow their own guidelines. When Baltimore City Lodge 3 first brought this up over a decade ago, at Baltimore City, there were over 300 officers with unsafe body armor. As recently as December 2025, there are still dozens of officers assigned unsafe armor. We have exhausted all internal avenues to resolve this issue. We've also heard from other members across the state having similar issues of getting safe body armor to all of their members. This legislation takes a balanced approach, ensuring officer safety without overburdening the agencies, without significant costs, and it resolves an important safety issue. Strongly encourage support for this bill. Thank you.
Good afternoon. I'd first like to thank Vice Chair Waldstreicher for sponsoring this bill for us. I won't belabor the points that have already been made, but this is a safety bill. We have laws on the books that mandate seat belts in cars, mandate car seats for children, and the list goes on. However, there is no law that mandates that a police officer gets sent in service with an actual vest that is in service and not expired. Manufacturers will not warranty the vest after the expiration date, so they have to be replaced. Otherwise, the officer, if injured afterwards, would not be covered. It's a simple thing that is most agencies have policies in place to make sure that this does not happen. And what makes the violation in most agencies is just that, either not following the policy that you do have or not having a proper one put in place. And once in a while, you do find that they just divert money elsewhere and choose not to spend the money on the officers that year, which is unacceptable. That is the reason why we have put the piece in there that would say if a department violates this, that they could be at risk of losing some GO-CAP funding, because we learned from this body that that's a good thing to put in place to ensure that agencies follow the rules that you all put in place. If an agency is doing what they're supposed to do, this will never be an issue for them. The only ones that have to worry are the ones that aren't doing the proper things. Like Clyde had mentioned, there are funds out there to buy these vests for officers. Most agencies, the financial piece is not an issue. It's just a lack of doing what's right to monitor and ensure that the vests are ordered in a timely manner. With that, I encourage a favorable on this vote, on this bill.
Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston. I'm here today on behalf of the Maryland State Fraternal Order of Police, and we ask for your support on this bill. We thank Senator Waldstreicher for sponsoring it. As already said, this bill is of extreme importance to the FOP because it goes right to the heart of safety and the safety of our officers. You know, after reading the bill and speaking with the Chiefs and Sheriffs Association, we recognize that the bill could be amended in such a way to allow for the fact that, let's say, an agency ordered vests, let's say 6 months out in advance before the expiration, and they find that there's a shipping delay, unforeseen circumstances, manufacturers, delay, and if it's a reasonable excuse, then the GO-CAP funding would not be suspended. And I think that's reasonable and it makes sense if they are able to show, hey, we attempted, 6 months in advance to get this vest, and, due to circumstances that out of our control, we weren't able to get it, then their funding shouldn't be suspended, but the officers still should be put on administrative leave so that he's not put in harm's way. With that, we ask for a favorable. Thank you.
Oh, thank you. Well, Mr. Boston, thank you for that last part, because one of my questions was, did you read the chief's suggestions for amendments, particularly because they make the point that some of the very funds that might go to paying for this kind of protection might be frozen, which would be an inadvertent consequence.
Right.
All right. But the larger issue, which could go to anybody in the panel, is currently, if I'm reading the summary right, the bill is saying no law enforcement officer can do anything other than, I assume, administrative duties or in the office, unless they are issued protective body armor. So currently, what is the policy across the state? And I'm not just thinking state police in Baltimore City, but little towns all across the state with 3 or 4 police officers. Are they required now, or they send people out to do other than administrative duties, and they're not issued protective body armor? What is the state of the state here?
Yeah, unfortunately, what we found that there is no policy that requires that a police officer's issued body armor statewide. I mean, it's the equivalent of a firefighter going into a burning building without
a hose or
an
something.
oxygen tank and a mask. So, yeah, that's no requirement.
Why I'm asking that is I was surprised, and I'm very supportive of the idea of the bill, but there's no indication that this has any fiscal impact. But I don't know that to be true when, if you make the statewide, every nook and cranny, every size law enforcement agency, group, whatever you want to call it, one sheriff town would now have to go out and get body armor. I'm not against the body armor. I'm worried about getting funding, enough funding, because you can do this. But if we don't give enough funding to GO-CAP or whatever, then we've got some law enforcement people in a terrible dilemma. I've got a law that says this, and I've got no money. So how are we going to fund this? Because I'm a little incredulous about it having no fiscal costs for many of the many small places.
Yeah, all police departments, although it's not a requirement, it's a best practice, industry best practice that they issue body armor. So it's always factored in the cost of hiring a new police officer or someone transferring in. They factor in the cost of the vest, and it's never been a money issue. And mostly it's just an administrative issue.
I would appreciate getting some really firm confirmation of that, because I definitely understand the larger counties, the central Maryland area, but I come from a county with some small towns. They have pretty good police, by the way, but at one point when I was young, these were very small police forces, and I can only imagine there still exists plenty of them in the small areas, in the rural areas. So I'd like to get some more confirmation on that. And then I think that might be the entirety of it. I think there was one other question I had. Just give me one moment. And the state police gave sort of a generalized information report, which is smart. They kind of indicate that generally in this industry, manufacturers give about a 5-year life to their body armor. Do you all agree with that's about right?
Yes.
And then best practices, according to state police, is they start sending out some notices around a year in advance of the 5-year time frame. Is that?
That's fairly accurate, yes.
So if we were to make this statewide, sort of the best practices of the state police would be what we would expect law enforcement to do across the state, because most of this will be on a 5-year cycle.
Yes.
And the best practice would be generally getting out and starting to get ready for that 5th year about a year in advance.
You're absolutely correct. Yes, ma'am.
Very good. So just get back to me on the fiscal aspect of the bill, and I appreciate it very much.
Yes, ma'am.
For the sponsor, where we are, I would support the legislation, but I'm curious, under the definition, we're just dealing with law enforcement agents. However, I know growing up, my father was an officer with parole and probation. And the issues that I'm hearing from everyone on your panel, they had the same thing. They were issued old body armor. Would you be open to that type of an amendment? So that anyone?
I'm open to it. I believe that issue was solved last session.
Did we?
As you recall, there was a bill, there was a murder in my legislative district, and
we took care of them?
What's that?
We took care of the, very good then.
Yep.
It sounds, thank you.
All right, see no further questions. Well, hey, thank you. We met over the interim, and I liked the bill then, and like now, so thank you for coming forward, and thank you to the sponsor for bringing it. Seeing no further questions, that'll be the end of the hearing. Thank you. Thank you. Oh, is there? Let me see. All right, so we've got Clyde Boatwright, Angela Castillo. Is Samira Jackson? Come on up.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the Judicial Proceedings Committee. Thank you for the opportunity to testify this afternoon. My name is Samira Jackson with Manus Canning, and I'm testifying on behalf of the police chiefs and sheriffs. Our clients wholeheartedly support the intent behind this bill, and the safety of our officers is both paramount and something that's not to be taken lightly. Ensuring our officers in the field are equipped with protective body armor is of the utmost importance, and we ensure that they meet the National Institute of Justice's standards. We respectfully request 2 amendments to ensure this well-intended legislation works in practice and does not unintentionally create operational or administrative challenges for agencies. First, the bill requires that body armor be replaced before the expiry and the suggested expiry date. And while agencies strive to meet this goal and have policy internally to meet this, it's very difficult to determine if there's going to be a supply chain or a delivery variable, such as manufacturing delays or backordered inventory. And Mr. Ralston touched on that. This could make the strict timing within the 31-day time frame really difficult for agencies to meet. So we would propose an amendment that it would allow for us to order the replacement body protective armor ahead of the expiry to give us some cushion for back orders. Secondly, we also request that the reporting requirement piece from the Maryland Police Training and Standards Commission is withheld from this bill or stricken, as well as the withholding of the grant money. As mentioned, there are several grants, specifically including those from programs such as Body Armor for Local Law Enforcement, also known as BARM, as well as the BJAG program administered through GOCAP that allow for agencies to order this protective body armor for their police officers. So we would request that the funding would not be stricken, and we'd also request that we could have a little bit of cushion room for ordering these protective body armors. We request a favorable review with amendments. Thank you. Great. Thank you.
All right, with that, that will end the hearing for Senate Bill 510. We're now going to go on to Senate Bill 512, just really quick because the witnesses, short witnesses. The next two bills have longer witness lists, so 512. All right, I think I do have some witnesses here to testify on behalf, but if not, I'm going to get started. Madam Chair, members of the committee, Senator Smith here to enter into the record Senate Bill 512. The mechanics of the bill are actually straightforward. This is going to be a policy call that we'll have to make, and I'll explain the mechanics of the bill. But I thought, hey, Debbie, how are you? I thought that there were some excerpts from MCASA's testimony and MSAA's testimony that I thought were particularly compelling as to why I think this is a good policy posture for us to move into. And I'll just read some of these statistics that I was unaware of, but very shocked to read and to understand. Nearly half of victims stalked by an acquaintance were sexually assaulted by their stalker. 48% of sexual assault survivors 18 to 24 also experienced stalking. And this is something that hits close to me because I'm still in the Navy Reserves. According to a Department of Defense annual report on sexual assault in the military, 22% of women and 23% of men experience stalking either before or after a sexual assault incident. Approximately 1 in 3 women and 1 in 6 men will be stalked in their lifetime. Most stalking victims are stalked by someone they know. 77% of female victims and 30% of male victims of stalking are stalked by a current or former intimate partner. And then from MSAA, and I know, Debbie, you'll go into this, there's a high correlation between stalking and homicide. 76% of female homicide victims had been stalked by the person who killed them. 67% of female homicide victims had been physically abused by their intimate partner. 89% of female victims who were physically assaulted were also stalked in the 12 months before their murder. 79% of abused female homicide victims reported being stalked in the same period that they were abused. 54% of female homicide victims reported stalking to the police before they were killed. And so I think the connection between stalking and serious homicide and criminal behavior is, the correlation is, I think, clear there. I was actually very shocked to learn this. And so now to the mechanics of the bill. The mechanics of the bill are very straightforward. Today, stalking carries, if you're convicted of stalking, it's up to 5 years of incarceration and a penalty of up to $5,000. Convictions for stalking are very infrequent, and our prosecutor will explain to you why that is the case. But what the bill does is it alters penalties for stalking if the person who committed the act, they committed the act of stalking, and either of these things must be true. They had an interim or temporary or final protective order in effect against the person at the time of the offense in which the victim was the petitioner. The person had a court order in effect against the person at the time of the offense, prohibiting the stalking of the victim. They had previously been convicted of stalking. They had previously been convicted of stalking under the law of another state, which would be this crime under a similar crime under the statute. It also raises the penalties for this second and subsequent offense, so to speak, for up to 10 years and a $10,000 maximum fine. Again, the statistics are, I think, very jarring. The lack of prosecution under the current statute is also jarring, and the correlation between stalking and serious criminogenic behavior is also shocking, and the gap in the law that I perceive this bill to be helping to fix is going to, I think, help a lot of people and deter a lot of people from continuing behavior that has resulted in a lot of terrible outcomes over the course of the year. So with that, Madam Chair, members of the committee, I respectfully request a favorable report. I'll turn it over to my panel and then sit by it for questions.
Good afternoon.
Come on, stand up to the
Chair,
sorry.
Chair Smith.
Could you stand up to the podium? Sorry.
Of
Yeah,
course.
sorry.
Sorry, I'm forgetting where I am. Apologize.
Thank you, Chair Smith. Good afternoon again, Madam Chair, members of the committee, Chairman Smith. My name is Debbie Feinstein, and I am Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I also have the privilege to co-chair the Special Victims Subcommittee for the Maryland State's Attorneys Association, and I'm a member of the Governor's Family Violence Council, and I've been a member of that for many years, and have chaired through that council a subcommittee of representatives from around the state to look at the issue of stalking and lethality. We've spent many years working on this. We last made an attempt to address the gap really between the seriousness of stalking and the penalties and the level of offense that it is. We tried in 2022. It was a very similar bill with a couple of additional modifications this year. And the reason that we're here is because of all the statistics that Chair Smith just related to the committee. There's a very serious and correlated nexus between homicide and between stalking. We see a significant percentage of intimate partner homicides where there was stalking in the history. I also happen to chair a domestic violence fatality review team, and we see this often, and I sit on a statewide group that the Maryland Network has that looks at, again, this type of nexus, where it exists and how we can go about preventing it. I would also like to note, and I have a million things that I could say, I know I'm going to run out of time, but I think it's also really important to note that we are very out of step with the rest of the country. We did a 50-state survey that I think I neglected to send to Chair Smith, so he didn't have an opportunity to comment on that, but I'm going to tell you the results now and can definitely follow up. I just counted again, there are 41 states that make stalking a felony under certain circumstances. There's us, and then there's 8 states that that have options for aggravated penalties. They don't classify it as a misdemeanor or a felony, but do give options under certain circumstances, like repeat offenses, like when there's a court order or protective order, where there can be an aggravated penalty. So we are way out of step. And I have lots of examples from Montgomery County that I brought with me that I would love to share, but can also share at another time. But these examples really highlight the need for this bill. And I can also, if the committee's interested, speak to what Chair Smith mentioned with respect to the numbers of prosecutions.
Thank you, Ms. Feinstein. I think we have a virtual witness signed up as well.
Yes.
Abigail Ullman. Ms. Ullman?
Good afternoon, Madam Chair and members of the committee. My name is Abigail Ullman, and I'm here on behalf of the Washington County State's Attorney's Office and MSAA to testify in favor of Senate Bill 512. Because I'm a prosecutor in a smaller jurisdiction in district court, I have a lot of cases where I communicate directly with the victims and law enforcement. But I had one such case recently that really struck me. The victim contacted my office in September 2025, indicating that she was afraid for her life. She didn't know what to do or who could help her. She said that she had obtained a protective order against her estranged husband in August, had privately filed charges against him for violating the order, and that she had submitted about 300 screenshots to my office in support of the charges. Through talking with her and looking at the materials, she presented clear allegations of stalking, harassment, and hundreds of violations of the protective order. I put her in contact with detectives who compiled the evidence, and we worked together to determine the appropriate charges. We reviewed threatening and harassing calls and texts and evidence that while the protective order was active, the defendant had attached some type of AirTag type tracker to her car and had taken pictures of her through her windows from outside of her home. We shared in that fear for the victim's life and could not believe that the most serious charge was a misdemeanor with a maximum sentence of 5 years. The case was recharged, but because all of the charges were misdemeanors, the judge eventually set bond and released him on GPS home detention. He did end up pleading guilty. He's currently on probation, but I still worry about this victim daily. And I just wanted to point out that even in Western Maryland, we get a bunch of these cases, and they need to be taken more seriously. So I would urge you to submit a favorable report for Bill 512.
Thank you. I would be delighted to hear your data. I'm very supportive, but before I do that, I just wanted to highlight, I think there was a recent case that just struck me so badly because a woman had a protective order, and I think she had 2 children and her estranged husband had 2 children. She had the protective order. The husband, I guess, threatened the children, and I don't remember if it was their shared children or not, but anybody gets hauled in for a violation of this protective order, and the court ultimately says, I think you've learned your lesson, and released you over the protestations of everyone, and within 24 hours, the man went and killed the woman. This just happened in Maryland. So, you know, I don't know what we do when these sort of circumstances happen, but what I appreciate from the state's attorney is if you could just briefly tell me how, with some data, how this approach, which I think we're an outlier on, would help us, not so much in the situation I just referenced, but help us, I guess, keep in jail some of the worst of the worst people in these circumstances. But as I can just said, and that the lady just said, some of these, no matter what we do, it doesn't, you know, we aren't protecting enough women enough of the time. But you said, I'd just be interested, you have data that would say this approach is going to help us maybe combat some of the incredible data this chairman referenced about the link between homicide and stalking or rape and stalking?
So, and I think I'm really going to speak more anecdotally. I know the data, the hard data indicates that there are not that many convictions for stalking in the state of Maryland. So that we know for sure.
Okay.
I look at my own jurisdiction and have been looking at it for the past 5 years as I've really started to study this issue. And what we realized, and we actually made a change in our jurisdiction and our internal policy on how we handle stalking cases, because so many of the cases come in through the citizen-generated complaint board, through our group, so it comes through the commissioner. Because it's a misdemeanor, it's often like patrol hears about it. It doesn't go to a detective. It's not taken seriously.
Yes.
And so we have something that's handwritten by a victim, and my office now investigates each of those, and we do that within my division.
Okay.
Most jurisdictions don't have the resources to do that, and I certainly appreciate it, because again, the nature of the offense is incompatible. It's not commensurate with the seriousness of the offense. And the examples that I was going to give and can speak to briefly relate to someone who there's a protective order and is continuing to threaten to kill, to stalk, to put cameras in someone's house. We have that case. And the most serious thing he could be convicted of in that case was a 5-year misdemeanor that's not a crime of violence. And so the maximum sentence that he could even do would be a quarter. Well, he would be eligible for parole. Not that he would do. He could do more. He would be eligible for parole after doing a quarter of that sentence. Another one where someone was out on bond with a condition not to contact the victim, where he, again, continually threatened the victim and sent a million letters, or not letters, a million different types of contacts. It was texts. He went to her home. He was striking the glass window in her house. He was sending letters. Sorry, he was incarcerated, continued to call her, continued to mail her letters, threatened to harm her, and again, threatened to come over, kill her, and damage her car over 50 times. That was while there was a bond condition in effect to have no contact. This law covers that gap because it would elevate it to a 10-year felony.
I got you.
So those are the type of circumstances that we're looking to get this elevation for, and that, again, almost every state in this country, except for Maryland, recognizes that under those circumstances, the lethality nexus is even greater, or the fear of lethality is even greater. And so we have to give a penalty that's commensurate with what the offense is.
And now just a technical question. The way that, I'm sure it's well written, I just don't understand. We have certainly a second offense, if you are a violation of this, would be if there's already a temporary, permanent, or interim, protective order. Then 2 is, wait a minute, the time of the offense prohibited the behavior described in Section A. So is that second broader, would that also be a protective order in general, an interim, final, or what prohibited behavior? It looks to me like you're saying a court prohibited this behavior under some order.
That's what I was referring to, an example, like a pretrial condition. You cannot contact the victim.
I gotcha.
Or an individual that's on probation. You cannot contact the victim. So those are those circumstances. It may be that they're on probation for a second-degree assault. So it wouldn't qualify necessarily for under, a repeat offense for stalking, but it would still elevate to a felony if it's a second-degree assault and it relates to the same victim.
Thank you very much.
Yeah.
All right, thank you.
Thank you. And with that, that concludes the Senate bill hearing for Senate Bill 512. Thank you.
Thank you. All right, appreciate it. I'll talk to you soon. I'll give you a call.
Calling next, Senate Bill 525. Is Senator Washington here?
Hi. Great. Mr. Chair, I know I don't have a vote in the committee, but I think that's a great bill just presented. Look forward to voting for it on the floor. Hello, colleagues. Great. Senator Mary Washington here to present Senate Bill 225.
No, thank you very much. I just wanted to know if you needed to sit, if you needed.
Oh, I'm okay for now.
Got it.
Yeah, I'm okay.
Of course.
I'll lean on this one, and I appreciate that. It adds a new section to the criminal procedural article to grant district and circuit courts, make it very clear that they do have discretion in expungement determinations. It creates a good cause pathway for expungement for certain convictions after a person has completed their entire sentence and has also waited the additional 5 years for the misdemeanors or 7 years for the felonies. So again, let me be clear, because we've read the opposition letters and also people who've reached out, that the bill does not create automatic expungement. This committee has addressed who qualifies for expungement for a number of years, has already done that, excluded certain crimes, and it does not erase any type of serious offense without review. Okay, but what it does allow is to examine a person's full circumstances and determines whether or not continued public access to that record still serves justice. Nearly 1 in 4 Marylanders has a visible criminal record, and each year approximately 15,000 people return home from incarceration in our state. And for many of them, this sentence on the record still continues to be a barrier to employment, housing, and a range of reentry resources that they need to continue on with their lives. More than 90% of the employers and landlords conduct background checks. So I know this committee is very serious about public safety. I know justice reinvestment was something that this committee has spent a tremendous amount of time. Reentry is a part of that, and expungement is a part of the integration that is needed. So here's the problem. Maryland has laws that prevent people from accessing the expungement relief that they need. The unit rule prevents expungement from an otherwise eligible charge if any other charge in the same case is uneligible. So while you may have 2 charges, one that's eligible, we're not able to move forward on that. Secondly, any subsequent conviction statute bars expungement if any new charge, no matter how minor, is filed during the waiting period. And finally, a person who's completed their sentence 15 years ago may be permanently barred, not because a judge reviewed their case, but because of, right now, our rigid statutory categories and technical violations. So the bill addresses those roadblocks. Some of the examples
don't really need to get into the examples of that we really need to, that we're invested in the person establishing that they are rehabilitated, that they pose no risk. So none of those things go away under this bill. The safeguards still remain very strong. The bill requires a hearing. The burden stays on the petitioner to demonstrate why relief is warranted. The state's attorney and any victims who receive notice, they may oppose it. The court retains full discretion to deny any relief, and a person may only petition once every 3 years. So we trust the courts to impose the convictions that alter lives, so we also must trust their discretion when we can trust it to granting these expungements. So there are 3 amendments that are proposed by the Maryland Judiciary that we wish to agree with and let you know that we do. One is that the petition should be filed in court in which the conviction was entered. Makes a lot of sense, it's a mission. Number 2, that the hearings only be held if the petitioner is statutorily eligible. Seems like that omission may imply that anyone, everyone has to have a hearing no matter what. So as drafted, it doesn't make that clear. And 3, that there would allow for a window of eligibility to have their petition dismissed without prejudice. So if they petition a day earlier or a day late, then it certainly would be dismissed, but it can be dismissed, allowing for it to return again. So on my panel, these are the people who work this every day. I just am a quick study, and I've just, over the last couple of months, have learned a lot about it. Christopher Dews, out for justice. Megan Dermott, Attorney General, didn't do that, no promotion there. Attorney at Maryland Legal Aid. Zachary, Center for Urban Families, which is really key. And also Saquon Merritt, an impacted person and business owner. So I thank the committee for your time. I respectfully request your favorable report. And after the panel has spoken, I'm happy to answer any questions you might have. Thank you. So I think we have Chris first.
Christopher Dews, representing Out for Justice. Out for Justice is an organization run by returning citizens for the purposes of assisting them in reacclimating back to society. As the good senator has very well established and said everything that needs to be said, I'm just gonna, me too.
Good afternoon. How you doing? Saquon Merritt, founder of Lightning Electric in Baltimore, Maryland. Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Saquon Merritt. I'm founder of Lightning Electric. I'm here today to support Bill 0169 because access to capital is the difference between a second chance being real or just something we say. In 2012, I was sentenced to 25 years on a drug case of possession with intent to distribute 2.3 grams of heroin. And that number still hits me, even when I say it out loud, because it shows how fast life can get erased and how hard it is to earn your way back into society, even after you've changed. I did the work to change inside. And when I came home, I didn't ask for pity, I just asked for an opportunity. I came back trying to build. I built a licensed electrical contracting company. I built the team, I built the pipeline for people who need a real chance, especially people when their background's like mine, because I know what it feels like and they need to be hired. Here's what most people don't understand. When your justice is impacted, when cash gets tight, I can't just go back and get a job to stabilize cash flow, because I still have the record. I've tried to pivot, I tried to switch gears, I've tried to take the safe route and go earn a heavy salary so I could cover some of the gaps of a small business owner, especially a commercial electrical contractor. But those doors don't open for everybody like me, because my background still shows up and it still has blocked my opportunity, even for capital. So as an entrepreneur, this isn't just my dream, it's my pathway. And that's why capital matters so much. I'm running out of time. just hurry this along, right? When you carry a record, capital becomes harder to obtain. Risk models, they see my past and not my progress, and they block me. It's just not beneficial for the community.
Good afternoon, Chair Smith and members of the committee. My name is Zach Alberts. I'm the Director of Advocacy at the Center for Urban Families. We're a West Baltimore-based workforce development and family strengthening organization. I'm here to once again emphasize the effects of a criminal record on an individual's employment. Research shows a couple of things. Getting a job after incarceration is one of the main factors to reduce recidivism. We know a criminal barrier, as you all have recognized many times, is a significant barrier to employment. We are an organization specifically set up to help individuals find work, half of whom have some sort of criminal record. We have relationships with second chance employers. Even with all of that, individuals without a criminal record get job placements at a 20% higher rate. So you can only imagine what it's like when you're on your own without a support system. Only 10% of convictions in Maryland are currently eligible for expungement. PWID is, conspiracy to distribute is not, right? Same effective conviction or same effective activity. Furthermore, we know that individuals, when and if they recidivate, the vast majority are recidivating 2 to 3 years after release from incarceration, well before the waiting periods for good cause expungement would give an individual a chance to ask for expungement relief. It is a fictitious person who is going to wait 7 years to commit a crime again because they want expungement relief, right? First of all, I would think the threat of incarceration is a little more motivating than the threat of not getting an expungement. Secondly, we know individuals, many, if not the vast majority of crimes are crimes of need. When you have access to employment, the urge for that goes away, making this a pro-public safety bill. And again, I would emphasize, as the good senator emphasized, this is not guaranteeing expungement to anyone. It is giving folks a chance to prove why they deserve it. Thus, we request a favorable report. Thank you.
Good afternoon to the committee. I'm Megan McDermott. I'm an advocacy director at Maryland Legal Aid. Expungement of convictions is a strict statutory process. There is a list of offenses in the code, and if the offense is not on that list, it cannot be expunged. I've been in court countless times when a judge has said to a client from the bench, "I wish I could expunge this case, but the law will not allow it." This usually occurs in one of two scenarios. The first is the unicorn, someone a lot like Mr. Merritt. This is the client who has done everything right for the last 20 years. The unicorn might have screwed up when he was young, but since then he's gotten a job, raised a family, volunteered, and generally been an active contributory member of the community. And he's not reoffended. But he can't get a singular offense from decades ago expunged because it's not on the list in the expungement statute. The second situation is a client that has a case that is very similar to a charge on the list, but it's not exactly the same. The client who can't get their trespass on private property expunged because the statute only allows for expungement of trespassing on posted property, or the client who can't get their open container citation expunged because the eligible offense is drinking in public. Or there's the client who was charged with street walking in the late 1970s, but couldn't get an expungement because prostitution is eligible, not street walking. The statutory framework of the current expungement law provides no flexibility in these matters, even though these are synonymous offenses and my clients really deserved a second chance. Senate Bill 520 provides that flexibility, that judicial discretion, while also creating specific guardrails to ensure that only the most deserving Marylanders receive a good cause dispensation. We urge a favorable report. Thank you.
Thank you so much. Questions for this panel or the sponsor? All right, seeing no questions, we'll move on to the next panel. If you've already testified, please let me know. Christopher Sweeney, Trina Selden, and then we've got virtual testimony from Guy Powell and Stephen McDonald. Are Christopher or Trina here?
Sweeney is not.
Okay. All right, then let's move to our virtual testimony. Mr. Powell, I see you. Please go ahead.
Yes, how you doing? My name is Mr. Powell. How you doing today? I am representing the organization Healing Services, which is my private practice. I am a licensed social worker since 2003. So I've been licensed by the state and trusted by the state to take care of others. I'm here today to advocate for the good cause expungement. The reason being, I am aware that at least in Maryland, there's 1.7 million Marylanders that have a criminal history. But what happens is that is providing barriers such as employment opportunity, shelter, and we all need, that's the basic need of every human being, shelter, your licensure opportunity at the state level, and also voters suppression. So with that being said, that causes problems. That causes problems for Marylanders. And right now, we know that at least 85% of like employers as regards to unemployment, they look for background checks. You may have someone who's did some time and then they come back, try to re-entry society. And for example, if they have a child with someone, the woman can't allow him to live in there if he has a criminal background. That was illustrated in 1974. There's a movie called Claudine, just to give you a note. But we know that the unit rule, that doesn't prevent expungement because that creates a barrier. It's just one rule out of many that creates a barrier. So I'm asking, please, in advocating the petition for just a just cause, for a judge can look at this individually. And I can just think of my example. Personally, I was convicted for assault back in 1991. Mind you, I did no
Mr.
jail
Powell?
time. Yes.
If you want to wrap up, we'd love to hear the end of your testimony.
Right now, I was convicted in 1991 to 1995. I served no jail time. I was waived from 17 years old into the adult system. From 1995, we know from 5 to 15 you have to be clean. From 1995, 1996 until now, it's been 29 years. I've never been in trouble, and I'm just saying I own my own practice. I am a licensed social worker. I am a mental health therapist, and it'd be great if the lower courts can judge someone individual situation, and I respectfully petition for this expungement, good cause
Thank you,
expungement. That's it.
Thank you so much for your testimony, Mr. Powell.
Thank you so much.
We'll now, in the virtual room, go to Mr. McDonald. Is Mr. McDonald in the virtual room? Hello, Mr. McDonald. Go ahead. And Mr. Powell, if you could mute yourself.
Okay.
Mr. McDonald, we're ready for you. Go ahead.
Okay. All right. Thank you, Chair and the committee. My name is Stephen McDonald, and I live in Charles County, District 28. I'm a master plumber and a tradesman in the local 5 plumbing and gas fitters. I'm here in support of Senate Bill 525. I was in a serious car accident when I was 18 years old that caused a serious back injury. I was prescribed pain medication to treat it and became addicted. I didn't understand the risk of addiction, and my doctor didn't educate me on it. And I began misusing my medication and ended up altering my prescription dosage. After my sentence, I was committed to recovery, and I've been clean for 16 years. College wasn't financially feasible, and my record would have created some barriers. I chose trade school to try to get my life back on the right path. I graduated from a 5-year apprenticeship program, then got my master's. I'm a licensed tradesman and a primary provider for my children and family. My charge falls under criminal law section 5701D4, and while other statutes covering almost identical charges under section 5601 that are not able to be expunged, mine cannot, just because of how the statute is written. Right now, judges do not have the discretion to review my case based on my rehabilitation. I've worked too hard to be held back. I feel everyone should get a second chance if they change their life for the better. Most union jobs I worked on involved government contracts or federal facilities which require strict background checks. Because of my record, I have been denied placement, promotions, and missed opportunities to advance after I've been to school for 8 years for this. I've been in front of 3 judges trying to get this case expunged, and each judge said they would have granted me my expungement just based on my accomplishments and how I've turned my life around, and which isn't common for opioid users like I was. But he said it's not in law and he couldn't do anything about it. So I urge a favorable report for this for many people and at least get the process started for at least low-level misdemeanors in the district court. I urge a favorable report. Thanks.
Thank you so much. Any questions for our virtual witnesses? All right, seeing no questions, it looks like we have one more witness. Is this? What's that?
Ms. Hill.
Oh, okay. Yes, please.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Trina Selden, and I am the founder and executive director of Out for Justice. I founded the organization in 2006 to assist people like me who are affected by the criminal legal system in navigating it and reacclimating to society upon release. 26 years ago, I received a distribution charge that I've never been able to walk away from. This led to crippling barriers to employment and housing upon release. In response, I worked diligently with the community on legislation to ban the box on employment applications and was ecstatic to see the reform reach statewide. Excuse me. Had I not created Out for Justice, I would not be allowed to work a minimum wage job despite having a bachelor's degree in criminal justice. Since then, I have worked with hundreds of returning citizens in similar situations, and Out for Justice has been at the forefront of policy reform to address these issues. Moreover, I've hired a core team of returning citizens facing similar barriers, and though I'm proud of my work, I can't hire everyone. Senate Bill 525 would allow me and my members to stand before a judge and argue that after we have completed our sentences and waited standard waiting periods, we may have our records expunged. This is not letting anyone off easy. Again, it has been over 20 years since my release, and I still can't move past this. As such, I urge a favorable report. Thank you.
Thank you so much. Any questions for this witness? All right, seeing no questions, we'll move to the opposition. I have Ms. Lauren Lipscomb, John Cox, Colin Campbell, Laura Wilt. Please come on up.
Somebody left their phone up here. Thank you. All right. Good afternoon again. I'm Laura Wilt with the Maryland Crime Victims Resource Center, here in opposition to Senate Bill 525. Maryland Crime Victims Resource Center does recognize the good intent behind reviewing the expungement laws that are in place in Maryland. We understand the efforts on behalf of those that you've heard from already today, but we ask you to also equally consider the needs of your community to be fully informed and determine for themselves what steps they will take to protect their businesses, neighborhoods, and families. Knowledge is power. We've all said that how many times in our lives. Specifically, Senate Bill 525, this bill requires a court to hold a hearing, but fails to require victim notification and fails to acknowledge the victim's right to participate. Criminal Procedure 10110 is the expungement law has been in place for a long time. That one specifies the victim's right to proceed. In this statute proposal, the bill, it specifies various factors that the court is supposed to consider before deciding on expungement. There is not one factor that ever considers the victim, the harm done to them, the restitution, whether restitution's been paid. And if you look at those factors, they don't even use words that mean, did he comply or she with the terms of their probation order? Yeah, they finished it. That doesn't mean they complied. So, you know, where are the factors that consider the victims and the harm to the community? I would argue that this bill, as we did in our written statement, violates Article 47, victims' rights to be treated with dignity, respect, and sensitivity. Syed versus State just was ruled by the Supreme Court. Victims have to have a right in proceedings to be heard if the sentence is modified. This violates that. Ask for an unfavorable report. Thank you.
Good afternoon. I'm Colin Campbell, an ASA with the Howard County State's Attorney's Office, here on behalf of State's Attorney Rich Gibson and the office itself, urging the committee to issue an unfavorable report on SB 525. This legislation is contrary to the purpose of the expungement statutes and consequently poses a danger to the public at large. Maryland law currently allows for the expungement of many misdemeanors and felony convictions. However, the General Assembly was careful in which convictions could be expunged and how long an individual would have to wait to file for expungement. This current legislation gives no consideration to the type of conviction expungement is being sought for, allowing a person convicted of murder, rape, or even distribution of child pornography to expunge their records within 7 years of the completion of their sentence. There are no exceptions within this legislation for convictions marked as domestically related or even crimes of violence. There are no carve-outs for law enforcement or the judiciary. Law enforcement, prosecutors, and our judges will not know the prior history of an individual and thus will no longer be able to tailor sentencing to that individual. A child care center or school system will no longer know if an applicant has a prior conviction for distribution of child pornography or sexual abuse of a minor. And a nursing home or a law enforcement agency will no longer know that an applicant had a prior conviction for elder abuse, rape, or even first-degree murder. This is clearly not in the best interest of the public and would ultimately pose a danger to Marylanders throughout the state. Unrelated consequences of this legislation would be the legal licensing, carrying, and purchase of firearms by individuals who are currently prohibited from doing so due to prior convictions for illegal use of a firearm or similar offenses. Convictions which currently would not be eligible for expungement and would be a reason for a carry license not to be issued and handgun sale to be declined. If the goal of this legislation is to assist individuals in successfully reintegrating into society after their release, there are better mechanisms to accomplish that, such as through shielding or the exclusion of law enforcement and the judiciary. But even then, the inclusion of all misdemeanors and felonies is far too broad to ensure public safety. For these reasons, I respectfully urge an unfavorable report on Senate Bill 525.
Vice Chair Waldstreicher, members of the Judicial Proceedings Committee, I'm John Cox. I'm Deputy State's Attorney for Baltimore County. I can bring a little bit of history here because I was in this room at the time of the Justice Reinvestment Act and all the efforts. And this committee is the committee that carried the largest workload in the Justice Reinvestment Act, and in particular the expungement statutes as they were changed dramatically at that time. In which we were then allowing guilty findings. Then Vice Chair Waldstreicher was instrumental several years later in changing the timeframes, lessening those timeframes for those eligible offenses. And very careful consideration was given to the offenses that ought to be eligible for expungement. There have been minor tweaks, changes that make sense that have happened over the last few years in adding something that may have been missed. This goes beyond the pale. This removes, in effect, any affect of 10-110 of the criminal procedure article. Senator Washington said it adds a section. It totally removes the necessity or the cause of 10-110. It was interesting to read the fiscal and policy note because they couldn't tell what it was going to do. It didn't say whether or not it was repealing 10-110, but then fell back on the most recent legislation is probably that which controls. And so then we see a circumstance where we're going to have such an immense load, every single offense, murder, anything, would be eligible for and would require a hearing. And as Ms. Wilt indicated, it has totally removed the victims from this. It's removed the state even from the opportunity for input in this particular proceeding. It's set up factors that only address the defendant, do not address the issues that are important to the community and the issues that are important to the victims and to the state. We'd urge an unfavorable report.
Thank you. Questions for this panel? Senator James.
Thank you all, and I apologize. I was looking down on my phone This is my daughter's birthday, so I lost my daughter. No, I lost her. But what I'm grateful for you all is when bills like this come in, I know you feel like, do I have to come back to Annapolis? But you do, because people have to keep giving us the history. And you need to teach the history to others, because I wasn't here for, a great deal, almost all of what you're discussing today. So I need to hear all sides, but I need to hear from you all. And the one thing that I've been struck with for my 3.5 years here is there are a great number of groups, nonprofits, supporting people that have been incarcerated and jailed and committed crimes. That is fine. There's lots of them. But there are very few victims groups. And there's a reason for that, because I can tell you as a grieving mother, it is extremely hard to ever come down here and talk about anything. And to do it every year, or more than that, on a multitude of bills. So I don't want anyone to think, who's watching us, that because we have lots and lots of very effective nonprofits, and as I said, have a right to come here and tell us everything they want to tell us about the defendants and rehabilitation and expungement. Please don't let's give that a misimpression that there isn't a silent, huge group of people, larger than you can possibly imagine, who is grieving and who cannot bring themselves to come here. So again, you speak for them as well. Isn't that so? Sorry.
Thank you.
Thank you. Okay.
Thank you all. The gentleman from Howard County, if you could just step up for a sec. I think you raised a lot of important issues about how this might put us contrary to federal law, but the advocates made a lot of good points about analogous crimes that we may need to add. So do you think you could work with the advocates and Senator Washington, maybe Senator McKay, to see if there are, if there's a prostitution charge that is no longer utilized, but was effective in the 70s, that we didn't include in just reinvestment, we should put it in. If there's PWID equivalents that somehow we missed, I appreciate the history, but we're not perfect. And if we need to go back and revisit and add analogous crimes that are factually similar, that seems like a good path forward here. Is that?
Yes.
Okay,
Yeah.
Great. Thank you so much. All right, seeing no further questions, that concludes the hearing for that bill. We'll now go for our final bill of today, Senate Bill 483, Senator McKay.
Thank you, Mr. Chair. Can I have my panel come up? Of course. Thank you, sir. Come on down. You're the next contestant, JPR. Welcome. 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 Hey. Thank you, Mr. Chair. Thank you, committee. Senate Bill 483 is similar legislation that has been proposed to this committee for the last 3 years. The primary goal of this bill is to streamline the expungement process and ensure that individuals with eligible criminal records can have their cases cleared from public view without having to undergo the formal manual procedures. We all kind of know what this bill does. In respect of your time in the evening, I'm going to allow my panel to present. They are the smart ones of the group. I like to say I'm the eye candy. So I'm just going to turn it over. If there's any questions, please let me yield to my panel. But at the end of the day, look, I'm a second chance guy. You've paid your debt. You've done what the courts have said you should do. When you're getting out, you should be able to get a job. You should be able to get housing. And while I understand victims having their say, I understand the whole process, but at the end of the day, we either give people second chances, we either give them an opportunity to clean their slate. I don't know what the other option is. To allow them to go back and commit crimes and continue, we have to figure out a way that we're restoring people's lives so that they can become productive members of society. I'm willing to give them that chance. and I will hush up before I mess up. Thank you, Mr. Chair.
Thank you, Mr. Chair and members of the committee. My name is Dr. Laura Chavez. I am a resident of Frederick, Maryland, and the Director of Research and Data at the Clean Slate Initiative, a national nonprofit whose mission is to work alongside states to streamline the record sealing process and ensure that everyone who meets the requirements has eligible arrest and conviction records sealed through an automated process. I am here on behalf of the Clean Slate Initiative to express our strong support for Senate Bill 483, which aims to address and rectify the impacts of past records on individuals and communities. As of 2019, around 1 million adults in Maryland, or 22% of the adult population, have some form of a record. Arrest and conviction records present significant barriers to employment, housing, education, and social reintegration. Clean slate legislation has proven to be an effective tool for addressing these challenges by allowing individuals to have their records expunged through an automated digital process, giving them a fresh start. In Maryland, only 2% of people with convictions eligible for expungement under the current petition-based system get relief. Under the current system, which is costly and difficult for an average person to navigate, it would take 86 years to expunge all of the eligible convictions. On day one of implementation, Clean Slate will provide full record relief to 407,000 adults, or 40% of those with records in the state. 13 states and DC have enacted clean slate laws, including our neighbors, Delaware, Virginia, and Pennsylvania, and the positive impacts on individuals and communities has been substantial. Under the current system, the estimated aggregate annual earnings loss associated with convictions eligible for expungement in Maryland is $1.5 billion of taxable income, and that does not include income lost for those with non-conviction or arrest records. A recent survey of people with records in Pennsylvania, Utah, and Michigan, which have started implementing Clean Slate, found that nearly half reported improvements in employment. So thank you. We urge the committee to give a favorable report.
Thank you, Mr. Chairman and committee members. I'm Nan Gibson. I'm Executive Director of the JP Chase Policy Center. Thank you for the opportunity to speak in support of Clean Slate Automated Record Clearing SB 483. JP Chase has more than 600 employees in Maryland, and we serve about 1.3 million consumer and business customers across the state. We believe business has a role, indeed an opportunity, to help more people share in the benefits of economic growth. That's why our firm is committed to giving people across the country a second chance. Over the last 6 years, nationwide, JP Chase has hired more than 21,000 people with records whose history had no bearing on the requirements of the job they were seeking. We are actively encouraging other companies to do the same through the Second Chance Business Coalition, with more than 50 large companies across industries developing best practices for second chance hiring. But to achieve systemic change, we need common sense measures like Clean Slate to lower barriers to employment and create greater economic opportunity. You've heard the statistics. It's more than 400,000 people in Maryland who are eligible to have their records cleared, but very few pursue that process, even though they fulfilled their justice system obligations. And the estimates you've heard as well, but they bear repeating. It costs your economy, the Maryland economy, roughly $1.5 billion annually in lost earnings due to clearable records. This legislation can play an important role in getting more talent into in-demand jobs and careers that fuel economic growth. We appreciate the committee's consideration, and we urge a favorable report of SB 483. Thank you.
Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of SB 483, the Clean Slate Act. So today in Maryland, over 1 million people, 22% of the total adult population, have a record, creating lifelong barriers to jobs, housing, economic stability, and much more, as we've detailed in our written testimony. This body has already recognized that permanent punishment is not good for Maryland. It's not good for our economy. It's not good for our residents. And this body has carefully passed laws designed to provide relief for those who qualify. Unfortunately, however, there is a huge gap between eligibility and access. So research consistently shows that across the country, under petition-based systems, uptake rates are often well below 10%. But we are particularly bad in Maryland, where only 2% of those eligible ever receive the relief they are entitled to. SB 483 is a common sense, bipartisan solution already adopted in 13 diverse states and counting, including 5 of our neighbors in the Mid-Atlantic region. Clean Slate would automate the sealing of over 400,000 records using tools already tested in state government and embraced in the private sector every day. So the Expungement Reform Act was a huge step forward last year, and one taken very much with this next step in mind. Automation is how we effectively implement and scale the impact of these laws. It's also important to note regarding any fiscal note concerns that this is not just about easing the burden on would-be petitioners. SB 483 transitions us to a system designed to greatly reduce the judiciary's burden and administrative costs over time. We urge a favorable report.
Good afternoon, members of the committee. My name is Nicole Bannister. I'm the Director of Policy and Advocacy at the Responsible Business Initiative for Justice and also a resident of Prince George's County. RBIJ is an award-winning international nonprofit that works with companies to champion solutions that promote public safety, deliver justice, and strengthen communities. Since our inception, RBIJ has collaborated with companies of all sizes across 24 states to advocate for practical policy reforms that expand workforce opportunities and stimulate economic growth. We strongly support the passage of Clean Slate Maryland SB 483 to provide deserving individuals with a second chance that they have already earned. As you've heard today, a criminal record creates significant barriers to employment, housing, professional licensing, education, and many other things. Particularly around employment, individuals have a challenge in securing employment when 9 in 10 employers are still using background checks, and that an old record, even a really old record as we've heard today, can prevent a qualified job seeker's chance of getting a callback by nearly 50%. The current petition-based record clearing process is complicated, burdensome, and seldom accessed. We know that nationally, and even here in Maryland, it's even more than or 2% of individuals who are eligible are receiving expungement through the current petition-based process. Clean Slate legislation in Maryland would remove these barriers, automate the process, and ensure that all of those that are eligible are receiving that access to a clean slate and reduction of barriers. Passing automatic record clearing will help employers access a diverse, loyal, and underutilized talent pool to bolster the labor market. According to a poll by the Small Business Majority, 84% of small business owners agree that clean slate policies would open up a pool of applicants that they have that they need and that they want to hire. This means more money in the pockets of consumers, back into local businesses, and for the state tax revenue service. Removing barriers to employment reduces the need for government assistance, saving taxpayer dollars, and increasing prosperity. We urge a strong favorable. Thanks.
All right, any questions for this panel or the sponsor? All right, seeing no questions, thank you so much. Just going down my list here, Zachary Alberts, Eric Galley, Megan McDermott, Meredith Gerard. Whomever would like to go first.
I'm already standing. So. Chair and members of the committee, my name is Meredith Gerard. I'm the Executive Director of Shore Legal Access, and we urge your favorable report on Senate Bill 483. I came here today all the way from the Eastern Shore and have waited many hours to give this testimony because it would have a deep impact on all of Maryland, including our rural communities. At Shore Legal Access, we have assisted hundreds of people with criminal record expungement, but we've only scratched the surface. And it's not because people don't want relief, it's because the process is confusing, it's technical, it's very easy to get it wrong. And as a result, a system that should be simple becomes the barrier itself. This bill modernizes Maryland's outdated petition-based system, and Maryland should be a leader on criminal justice reform, and many states, as you just heard, right around us already are. Our neighbors in Pennsylvania made a relatively low-cost investment that laid the foundation for shielding of 33 million records. Marylanders want this reform. In a recent poll, Marylanders showed a clear majority in support of automated record shielding. We see firsthand at our organization how transformative this process can be. One recent client who would have benefited from this bill said that once he got his record expunged, because we had to go through that traditional petition process, it gave him hope because he had been experiencing homelessness that was caused by repeated denials due to his record. And today, he's gainfully employed. He provides essential care for older people in his community. And the national research shows that when records are shielded, people experience an average of a 22% increase in income. And that means stronger families, that means stronger communities, and increased tax revenue. We thank the committee for its leadership on reform. And so now it's time for our systems to catch up with our values. We respectfully request a favorable report on Senate Bill 483. Thank you.
Apologies, Senator, I was supposed to be on the first panel. Christopher Dews representing Out for Justice. Just throwing out there that Out for Justice every year hosts an all-night community resource clinic in which we go to the highest crime areas in Baltimore City simply to have people's records expunged. Having something like this in which the process is automated, specifically I believe this bill targets misdemeanors, would be a massive boon to us and boon to all the practitioners who do expungement work. It would just speed up the process. This bill does not necessarily alter the current petition process. That still stays in place while creating an automated system. It also allows, to earlier conversations, it also allows access to very specific sources, as this just removes it from public view. I want to say the CJIS, Central Repository, and MDEC. And so for those reasons, I urge a favorable report. I also want to throw out there that Mr. Galley also says me too for this specific hearing. Thank you. And I'm happy to answer questions about the bill or fiscal note and the language. Thank you.
Chair Smith, Vice Chair Waldstreicher, Zach Alberts, Director of Advocacy at the Center for Urban Families. I just wanted to address two areas really quickly. The first is as a workforce development organization who has justice-impacted individuals, we see every day the challenge with individuals actually accessing the expungement relief to which they are legally allowed to have. We rely on organizations like Maryland Legal Aid and Maryland Volunteer Lawyer Services to provide the expungement clinics. There are never going to be enough practitioners to meet the demand. It's just impossible. I tried learning myself as like a backup. It's very hard, it's very complex. Megan did a whole clinic and a college degree later, it's still challenging. This legislation would fix that. I also want to address, both with this bill and other bills, it often seems like folks advocating for expungements are set contra to victims or public safety. And I just want to say, as individuals that advocate for expungements, as a person that lives in Baltimore, lives in Maryland, we also care about public safety, and we see those two things tied together. You heard from an earlier witness, $1.5 billion of wages that Maryland doesn't have access to because of criminal records. Are we safer if Marylanders who have previously committed crimes have access to $1.5 billion of wages, or are we less safe? I know my clients, my family who lives in Baltimore City think we are safer. This provides automatic access to a right a person is entitled to, and we would urge a favorable report. Thank you.
Good afternoon to the committee. I'm Megan McDermott. I'm an advocacy director at Maryland Legal Aid. On its face, the current expungement process seems simple and accessible, but it's not. As this committee well knows, the statute changes every year, and each type of charge or disposition has a different set of rules. Conviction petitions require a filing fee, If someone can't pay the fee, they have to figure out how to navigate the fee waiver system. People often think that expungement is a simple administrative process, but that's not accurate. Many petitioners end up in court for expungements. Often people need a lawyer to help navigate this process, and if they cannot afford one, they turn to Maryland Legal Aid, Shore Legal Access, Office of the Public Defender, and other sister legal service organizations. At Maryland Legal Aid, we do our best to help individuals who need expungements. We advised or represented over 2,000 expungement clients in 2025, but there are simply not enough resources to provide representation for the over 1 million Marylanders who have a criminal record and might be interested in expungement. People with money and resources can hire an attorney, or they can take off work or secure childcare for court hearings. And they can probably navigate the expungement process on their own. But low-income people don't have those luxuries. Clean Slate helps everyone, petitioners, practitioners, and the courts, by doing away with court hearings and filing fees for already eligible misdemeanors, which helps to restore equity to the expungement process. We urge a favorable report on Senate Bill 483. Thank you.
All right, thank you very much. Questions from the committee? See none, thank you very much. Thank you all. And with that, I believe, this is Christopher Sweeney? Okay, he's not here. I believe that's the end of the proponents. Thomas Hignan, Trina Selden, and then we'll switch over to the opposition panel. So, Trina Selden and Thomas Hignan. Okay. All right, it looks like that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and Mr. Cox and Ms. Wilt. Welcome back.
Thank you. Thank you, Mr. Chair, members, senators. My name is Laura Wilt, Maryland Crime Victims Resource Center. Thank you for hearing me again. I am here again, once again, recognizing the good intent behind this work and the needs of those who have convictions and who have been charged in our communities. But I'm also asking, again, when looking at this bill, to consider the rights and needs of your community equally. In this particular bill, 483 automatically expunges a record of harm without giving victim notice or the right to be heard. That simply said, violates Article 47 victim rights. We have victim rights in Maryland. We must be treated with dignity, respect, and sensitivity. We have the right to be heard. Syed versus Maryland State was just decided by the Supreme Court recently. What that decision said, among many things, is if a court is going to modify or change a sentence, the victim has a right to participate in that hearing. That means notice and right to be heard, because there are instances when the state has one perspective and the victim has another. The victim has a right to participate. That right cannot be modified unless there's a constitutional amendment. So this law violates those victim rights, simply said. I understand the need for looking at these laws, but this is not the way to do it. It will clearly violate victim rights and not stand the test of time. So we do ask for an unfavorable report for 483. Ask you to always consider the needs of the victims and the harm. I'm looking at the list of crimes that would automatically be expunged. I mean, failing to obey a peace order, theft, numerous victim crimes are included in this, and we'd ask for an unfavorable report. Thank you.
Chairman Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings. I'm again John Cox, Deputy State's Attorney for Baltimore County. I won't recount the history again of the Justice Reinvestment Act that I just did a few minutes ago, but I think it's very important to address a couple of things. Ms. Wilt just mentioned that sometimes the victim's position is different than the state's. The state's not in this either. She pointed out that the victims aren't notified of these, and there are hearings, but the state isn't a participant either. If you look at what they're looking to do with regard to 10-105, and the probation before judgment, a person is not entitled to expungement if they've committed another crime since then. Who's checking? Who would be doing that in this automatic circumstance after those 3 years to see whether or not the person has committed another offense? Is the judiciary going to be doing that for every single case that comes across? And if so, are they looking out of state to try to see if they've committed another offense? With regard to the guilty findings, there's a structure there for the victims to participate and for the state to participate. The state is allowed to object to an expungement if it's not in the interest of justice, if the public safety is concerned, if the person has had a subsequent conviction, if restitution hasn't been paid. All of that is completely obliterated by this. There's an automatic expungement of everything without us being allowed to participate in that at all, to try to address any of that. It's disconcerting also is that the time frame runs from the time of disposition. When the person pled guilty, that's when the time frame starts. This person could theoretically still be in jail or still be on probation or still be on a sex offender registry, and they're going to have their conviction expunged automatically without any input from the state. There is a structure that is appropriate for people to get expungement of those that are deserving. This does not accomplish that at all, and it just guts it. We'd ask for an unfavorable report.
I ask you a question, Ms. Wilkes.
Yes, sir.
As you can tell from the last bill, I'm trying to see if there's some kind of solution here, because these bills come back year after year. As you indicate, there's no way this bill survives an Article 47 challenge. But what if there was a hybrid system where essentially the initiation was automatic, but then notice went to the state's attorneys and to the victims? Is there a way to move something like that forward, where the petitioner doesn't have to initiate it, the initiation is through legislation, but you still have the opportunity as a victim to be notified and object, and the state's attorneys, same thing. And if there's no objection, then the automation continues until the expungement is through.
That sounds like a way to creatively meet the problem. And we would love to be part of the conversation.
Excellent. Thank you very much. Further questions from the committee? All right, seeing none, thank you all very much. With that, that'll conclude the hearing for Senate Bill 483 and our hearings for the evening. Have a good night, everybody.
Thank you.